Hey, finally. Suppose.
Good morning, Judge.
It only took 6 years. How are you? Us. Fine. We're happy that you finally made it after all that time, you know?
Thank you.
Yeah, so, here, let Ramon in. All right. Mr. Das, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or $2,000 fine. I seriously have to commend your lawyer, Mr. Bose, who has just literally stayed with you 1,797 days old, and she has never, ever forgotten. Mr. Bose,
Yes, Judge. Good morning.
on the back, really. Just,
Thank
you are one and amazing.
Oh, good.
We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If we cannot afford one, one will be appointed to you.
Yes, Judge. On February 13th, 2020, officers were dispatched in regard to a major crash at the exit ramp of Bingle and Pinemont on Northwest Freeway. And the officer made contact with the defendant, who was observed sitting in the driver's seat with the keys in the ignition, with the vehicle still running, and the defendant was covered in vomit. The officer smelled a strong odor of alcoholic beverage and observed bloodshot eyes and slurred speech. The officer further observed the defendant drive in the vehicle and swerve across several lanes and strike a Toyota Sienna van. And that they followed the vehicle, and that's whenever they pulled over the vehicle and made contact with the defendant. The officer made contact with the complainant, who did not see the driver or the car hit them. They just felt the impact, which caused their car to spin out of control. And the officer then conducted standard field sobriety tests, HGN 6 out of 6, walk and turn 5 out of 8, one leg stand 3 out of 4. The defendant was read the DIC and consented to arrest. The results 0.112, 0.118.
You said he was in the driver's seat when
He was
cop
observed in
came
the
up.
driver's seat, still running, and keys in the ignition.
Mr. Das, I'm going to find that there's probable cause to go forward with your case. I'm ordering you as a condition of your bond not to consider alcohol, illegal drugs, or unprescribed controlled medication. You're also not allowed to drive unless you have a valid Texas driver license and liability insurance. Do you understand? Okay, you've got a great lawyer. Listen to her. She'll take care of you. Because you have a lawyer, I will waive your appearance so you don't have to waste your time coming to court. But just stay in touch with her. She'll tell you when you need to come back and what to do.
Sure.
Do you see a valid license?
I'm running it right now, Your Honor. It's eligible.
Great. So for now, I'm going to have you sign a receipt with Victoria. We'll have you get with pre-trial for your bond conditions, and after that, you're free to go.
Sure.
Thank you. Please. You are Victor Sanchez.
Yes, sir.
Mr. Sanchez, you're charged with driving on a suspended license. You are facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge. On January 11th, 2025, the officer was dispatched to a disturbance at a residence in Harris County, Texas. The officer made contact with the defendant, who was upset due to being in a motor vehicle crash. The defendant stated he did not have a license or insurance and that his insurance was suspended. The officer identified the defendant through NCIC and found the driver's license suspended.
They didn't catch him driving?
No, he made the statement that he was involved in a crash and that he further admitted he didn't have a license or insurance after, and he said,
I mean, what happened? Did an officer really just go to his house and just start questioning him?
so he was originally dispatched to a disturbance, and then he did initially just start questioning him, and that's when the defendant was upset and stated it was due to being in a vehicle crash. So the officer wrote that, and the conclusion is that he was driving based on that statement, that he was involved in a crash.
Take a seat for me in the jury box. I'm really upset because I got into a car accident. So then the officer starts asking him, hey, do you have license and insurance? And the guy goes, no. And then he just arrests him for driving on a suspended license. You know what I mean? I've never just, what's a crash? You know, what just, people say stuff all the time. That's,
It's with there being a crash.
Do we have
a little bit
an
more
offense
details.
report?
There's no offense
Can you pull
report.
the OR from Superion? So here's the thing, Judge. The Isn't this, I mean, this is
I've
like,
seen something like this before where they say something like that and they kick off a DWI investigation. Like, to me, investigating what happened with this alleged car crash isn't weird to me. What I am curious to see is what exactly the statement is and whether or not he indicated he was like in a vehicle for a car crash or if he indicated he was driving and there was a car crash.
that's what,
But I think the important thing is what he said prior. I think if there was an alleged statement, it came out after the officer checked his license. The first thing that the officer did was ask him for his license.
So,
Seeing him outside of the.
oh, sorry to interrupt. So asking for a license is a typical way to just identify people on scene. You know, like people give fake names, all of that.
sure.
Don't have an issue with
Then that makes sense.
Yeah, and like all the stuff so far, like you get told that there's a crash, you want to do some kind of investigation, ask the person for means of identification, get told I don't have a license or insurance, or sorry, and my license is suspended. I see in the DIMS.
He has no proof that he was even driving.
That's what I'm saying is I want to see the verbatim of the offense report to see if the statement is I was involved in a motor vehicle crash or if I was driving and I was in a crash. So that's kind of what I want to see in the full.
But what I'm saying is so what I'm saying is that the statement, it's important if that statement was before
And
he.
here's the thing, compounding this, he's on probation and here for a DWI. So that's why I'm like,
Let's see if he says he was
let me add
driving.
some fuel to your fire. So I guess let's do this. Do you want to put off a probable cause hearing and maybe do it Monday? Give you time to, further research?
So just you don't have to carry on.
Oh, that's right.
Okay, 1 second.
Tuesday, we're gonna get snow or what? Are we gonna close?
I just got an email, some reports are saying because of inclement weather. Because of inclement weather, they'll be closed, but I don't know. If it's
You think we'll be closed? I mean, they get one kernel of snow, the whole city stops.
Tuesday. So this court's closed on Monday due to the weather.
No,
What's MLK?
Okay, yeah, but I'm sorry.
No.
Yeah, it's a
So
holiday,
Tuesday or
like it or not.
Wednesday?
Tuesday, we might not be open because of the weather.
Yeah, it's the weather. It's supposed to get bad. Like,
Just
It's
an
supposed to be like 33 degrees.
It'll be fine. We'll be here.
I think we should all stay open. Just salt the roads.
do you want to take some time?
Let me pull this offense report and see what the offense report says. If, depending on that, then yeah, maybe what we need to do is have somebody actually watch the body cam and see what his verbatim statement is. Because if he wheels himself and says, like, hey, I don't have a license insurance and I was driving earlier while he's on probation for a DWI. I mean, frankly, it seems like he's kind of lucky that they didn't take him down or at least start the SFSTs and see if he was driving while intoxicated on this instance.
I mean, would your be, so I guess with him, if he did make that statement for the court, would you look to see when he made that statement or would it matter?
I think we need to look at everything. And I think that let's give you more time.
Okay.
Because I want you guys to make a full investigation to see, because if there's probable cause, I'm going to file a motion to revoke. So there's quite a bit riding on it.
If you want to give me a second, I'll pull the
So
water.
in the interim, I'd like to do conditions. Come up. You are not allowed to drive. Do you understand?
Sure.
You will be signing an affidavit with me today, promising me you're not going to drive. I don't care what is going on in your life. I don't care if there's a burning building and you have to save 50 kittens. You get into a car and drive. I can have a contempt hearing. You can be facing an additional 6 months in jail and a $500 fine every time you drive. Do you understand? You're also not to consume alcohol or illegal drugs, and I'm going to randomly test you to make sure that you're not using as well. So what we're going to do, Mr. Sanchez, is I'm giving the state and I'm giving your defense lawyer time because we're going to set this for a formal probable cause hearing. You are on probation out of this court for driving while intoxicated. You now have picked up a new case, but I want to make sure that there is probable cause before we go forward. Do not drive. Do you understand? All right. So we'll have you swear to this. I'm going to have you go to Victoria, sign a reset. So no drugs, no alcohol, no weapons. no driving. And then, we'll see him back on Wednesday. Okay. Thanks. All right, come on, Mr. Sanchez.
I'll just make yourself or make the court aware on that Mr. Excuse me.
Sanchez.
Yeah, Mr. Sanchez. So as I said before, he doesn't definitively wheel himself in the offense report, but in reviewing the 8 pages that have been so far uploaded to Superior, it's pretty clear that the suspect in this case was attempting to fight people on scene of the accident, and that's why he had to be detained. And then after he was detained, he was trying to kick out the windows of a patrol car.
You tell me him?
Yeah. So, you know, perhaps this is him. And this is, again, when I see somebody on a DWI probation, I'm not saying that he was like belligerently drunk. Maybe he was just truly angry because his car had gotten wrecked. The point is, even if he does not wheel himself in the body cam that gets reviewed by the ADA, we still have behavior that could result in his arrest and would still qualify, I think, as a basis for an MRP. So I think probably the most expedient way to handle all that is to file the MRP, allege both the DWLI and the fact that he was engaging in conduct that could result in his arrest.
But obviously, it didn't rise to the point where they would file charges, because if an officer felt that there was enough, I mean, I can't use that to
I think,
So they didn't file.
that's not fair.
I understand. I'm just saying, when I look at cases like these and I see behavior like that, that's what I typically, we always include, well, I like to include in my MAJs because all of the MAJs have the admonishment of no new law violations and the defendant shall not engage in conduct that could result in his arrest. Not that he is in fact arrested on that, but just engages in that conduct.
I got to imagine that if he was acting like that, you know, and it was because of some kind of, you know, alcohol or dope or whatnot, they would have charged him with another DWI. But they let him go. They didn't do anything. So
I think that I think it's premature because I would like to see the video, because what we're doing is just reading what his quote unquote character was that night versus us.
No,
Seeing the video, I think that's a little bit much more appropriate.
let's set it for Wednesday for a hearing. I want to give you enough time to look at everything and then we can come back. But
I can see that there are MP4 files uploaded with the last name of the officer on the case that I assume were the body cam, but I
And
don't
then-
know personally.
if you need anything beforehand, just let us know.
Okay. So that's assuming that the court's going to be open on Wednesday.
I think Wednesday we're gonna be okay. I think it's Tuesday.
With like the courthouse will exist and be open on the
Yeah,
days that we should have
I
docket.
think Wednesday we're gonna be okay. I think Tuesday's the issue.
Okay,
So,
got it.
We got Mr. Morris, Mr. Robbins.
Morris and Robinson. Good morning, guys. All right, so tell me what we're doing with these gentlemen.
We're reading extradition on both of them, Judge.
Okay. So. Mr. Morris,
Oh, you signed Mr. Morris's.
you are wanted out of the state of Louisiana for failure to register as a sex offender. Are you waiting for formal extradition?
Yes. Hey, Judge, I have a question.
Shoot.
Since the charge originated out of Harris County like 40 years ago, since I served time here since the state of Texas, they've been trying to make me sign up for this in Louisiana.
So what this is it looks like they filed a charge out of Louisiana, right? And they issued a warrant for one reason or the other, probably a failure to appear. It could be just a new warrant that, you know, Dave, do you have any?
My best guess, because I don't have the underlying offense, but the originating offense that required him to register as a sex offender did come from Harris County, but they might have had some evidence that he either resided there or had an appearance in
Perhaps
Louisiana.
got transferred over there?
Right, and so for
Or
some,
no, I mean, that wouldn't work.
Right.
I don't know. I have no idea. They give us so limited information here on what the underlying case, we don't even fight the underlying case. All we do is establish who you are and whether you want to fight extradition or not. Really. And you are Sidney Robinson?
So Judge, on Mr. Robinson, we'll have the waiver on the fugitive case. And then on the assault case, if you wanted to put bond conditions, I believe state wanted no contact.
Oh, music. So you're on bond for an assault here out of our court here. You were also wanted out of Adams, Colorado for driving under the influence, failure to display proof of insurance, and careless driving, and
I know, Judge. I know, but it's on there. It's one of the warrants.
low power scooter operation without a license.
Which is completely false. It was a Harley.
No, just,
We don't want to see.
you're waiving formal extradition on that case, right? Okay, so I don't know anything about are you representing him on the assault?
I am.
Wonderful. Alex?
Your cause number for the,
Assault,
yes.
254-7113.
I apologize, 254-7113.
113.
Okay. CBD then. That is correct. Let me see. Okay, I can tell you the facts of the case, Your Honor, if you
Okay.
want to do those. So on the assault, the officers were
Thank you.
dispatched to a welfare check at a residence in Harris County, Texas, in response to a disturbance. The caller, the witness, was met by the officer, and she said she kept hearing the female saying, "Stop it." The complainant stated she went to an upstairs bedroom and slept, and that the defendant entered the room, grabbed her by the throat, and lifted her off her feet. The complainant stated she did not have pain or impede breath due to the fact that she was very intoxicated and could not feel anything at all at that moment.
Did you say she was very intoxicated this
She was
year?
very intoxicated at that moment. And then on the morning of the incident, or on the 11th of January, the defendant woke up and they started verbally arguing again. And the complainant said that the defendant threw a box at her and hit her in the head. And the complainant said the defendant began to chase her in the backyard. And while she was in the corner of the backyard, the defendant ran towards her, threw her down in the mud, and began choking her with his hands. And the officer observed the complainant to have fresh bruising around the left eye and a red marking on the left and right side of the forehead.
Okay, Mr. Robinson, I'm going to find that there's probable cause to go forward on your assault case. I am ordering you as a condition of your bond not to have any contact with this person in possession of weapons. I'm also ordering you not to consume alcohol, illegal drugs, or unprescribed controlled medication. Do you understand? Okay, so the other thing is this, Shrey, is that he's on bond for this here.
Right.
What, do we know that Colorado's coming to get him?
Yes. So short answer is yes. I haven't heard anything else since the original.
Okay, so we need them to sign conditions. Now, you got to be aware that if you go back, if they end up picking you back and you go to Colorado, whatever happens there, you must remain in contact with Shreya here, because if you don't, we're going to issue a warrant here. And what's happening now will exactly happen over there, where you're going to be sitting in custody over there. And then a hold is going to be placed over here. And then you're going to have to come all the way back over here. All you have to do is remain in contact with her so we know what the situation is going on. And don't have any contact with the complaining witness's case. Don't pick up any new cases. Understand?
Yes, sir.
Okay?
And Judge, in case, for whatever reason, Colorado decides not to extradite and he is released in the next week, we're going to do a appearance required for the January 29th.
Okay. That sounds good to me.
Okay.
Okay. Have you heard PC on this flow yet?
Yes, sir. So, Your Honor, yesterday, she was on the docket actually so she was on bond for the case out of the 178th, a assault of a family member. They actually, we went up there yesterday. They had her on the docket. There was some issue with the bond and why she was in custody because she never got noticed. So we addressed that yesterday, but she picked up a violation of protective order because when she was arrested for the bond, for the warrant on that, the victim, the complaining witness, her husband, was in the vehicle with her.
And at the house, allegedly.
Yes, sir. Yes, sir.
Are you telling me that that's wrong?
No, sir. That is correct. And that is correct.
Because the only thing I'm doing is no contact, no drugs, no alcohol, and no weapons. That's all I did.
Yes, sir. If I may add, Your Honor, the prosecutors yesterday did call. They spoke with the victim who wanted the order lifted. Judge Susan Brown was covering the 178th. She said she was going to she was keeping it in place where she could not go to the home, but she was allowing contact.
Okay, I'll mirror her order then.
Yes, sir.
And I don't know, has a MOA been granted in this case? Do you see what the MOA is in Ms. Escobar's case? If a MOA if an order for protection has not been granted, I'm granting one now, ma'am. I'm issuing a protective order that identifies Mr. Longoria as a protected individual. You cannot commit family violence or assault against this person. Commit an act in furtherance of an offense under section 42.072 of the Texas Penal Code, which is the stalking statute. You cannot threaten, harass, use another person to communicate a threat or harassing behavior. You cannot be in possession of a weapon. You cannot go within 200 feet of the address listed in the order of protection. Do you understand?
Yes, Your Honor.
If you violate this court order, I'm telling you, at that point, you're going to get hit probably with another felony. And it's not hard. Now, you've got a great lawyer. Listen to him and he'll take care of you. Because you have a lawyer, I will waive your appearance. But it is your responsibility to stay in touch with him. If he tells me he can't get a hold of you, I'm going to issue a warrant for your arrest. All right?
I understand. Yes, Your Honor.
So we'll have you take a seat. We'll craft all the orders. We'll have you sign it. And then after that, you're free to go.
Okay. Would you
Right.
like me to sit?
You can go out there. Bo, do you want the same date as the felony?
Yes, sir. Please, Your Honor.
Done.
Okay.
Okay,
Thank
man.
you, Judge.
Thanks.
Take care.
What time does court start, sir?
Court starts at, I just read the sign, 8:30, sir.
What time did you get here?
I got in felony court at 8 o'clock, sir.
You had felony court today?
Yes, sir. Excuse my absence, sir.
It's okay. I mean, if you had felony court, then I'm not going to ding you.
It, well, 183 Judge Lane or something like that. Just been appointed January 1st.
So the one that's in 13 is getting transferred here? You've now picked up your third case.
Yes, sir.
You were not, don't say anything. You're charged with possession of marijuana again. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir. All right.
Your Honor, which possession case we're doing PC on, the one ending in 562 or the 962?
Yeah, 562. And then we'll do the other one right after.
Okay. On January 6, 2025, the officer conducted a traffic stop on the 3100 block of West Little York Road. The defendant's vehicle having a defective passenger tail light. The officer made contact with the defendant, the driver, with a passenger. The defendant gave permission for the officer to search the vehicle. The officer observed a clear bag of green leafy substance, which emitted an odor of marijuana between the passenger seat and the center console. The defendant admitted the bag was his, and the substance was known to be marijuana based on training experience. The weight was 50.4 grams or 1.77 ounces.
You have a license. You say he was a driver?
He was the driver, and the car had a defective passenger taillight.
Can you tell me if there's a valid license, please?
It's eligible, Your Honor.
Now let's do it on the new case, please.
Yes, Judge. So on January 10th, 2025, the officer stopped the vehicle for a defective stop lamp. The officer made contact with the driver, and while trying to confirm the vehicle VIN from the front windshield, it was blocked with a white card. So he asked the driver if he could open the driver door to confirm the VIN number, and the defendant, the driver, agreed. And while the door was open, the officer saw a small bag of marijuana in the driver door compartment. The officer detained the defendant, and the weight of the marijuana was 0.289 ounces and was known to be marijuana based on training experience.
Stops today, Mr. Martin. I will test you 45 days from today. And if you test positive for marijuana, I'm going to revoke your bond and put you in. Do you understand?
Yes, sir.
No more smoking marijuana. I'm making it a condition of your bond. Do you need a court-appointed lawyer, sir?
Yes, sir, for right now.
I'll have you fill out an application. If you qualify, I will provide you a lawyer today. And let me make one more thing apprise you. If you pick up a fourth case, I'm going to go nuts. Do you understand, sir?
Yes, sir.
Your attitude is that like this is a big joke, but I don't know why you're laughing. It's not a funny matter, and but
I have the right to speak.
No, don't.
Sir.
You have the right to remain silent. I have a bunch of DAs here. Whatever you say, they're going to try to use it against you. I'm just trying to impart to you that a third case, it's not a happy thing. Good morning, Ms. Campbell.
Hello.
Hi. You were wanted out of the state of Louisiana for unauthorized use of a motor vehicle. Are you
Yes.
waiving formal extradition today?
Yes, I'm done. I'll go to Louisiana and go deal with that and where I
You don't have
believe.
to say anything.
No.
Just yes?
Yes,
Okay,
no,
wonderful.
yes,
Well,
no, yeah, yes, yes, yes. Yes, you're hearing, yes.
okay.
Sorry, it's been a long day with breathing and.
Okay, you're doing great. All right,
Yeah.
good luck.
Yes, thank you, sir.
Mr. Godfrey, you know, this life is a journey. It's either a really great journey where you go on nice vacations, you buy nice cars, you buy nice clothes, or it can be a rotten, miserable an existence where you never have money. You're constantly fighting with everyone because you got no money. You have no education, so you'll never get any money. You have no trade, so you'll never get a good job. It starts now while you were 17. It doesn't start when you're 32. Life. You start to build your life now because there's only one way that you're going to go. You're either going to go up or you're going to go down. Make it a good life. And it starts with knowledge. Knowledge is power, and you can get it with education. And I want to see you do it. So you're going to get back into school. And number two, I'm going to test you 45 days from today. If you test positive for marijuana again, life is not going to go well. Do you catch my drift? So what we're going to do is we're going to bring you back in about 2 to 3 weeks. I want to see what you have done to get either back into high school or to work on your GED. If you need help, we have resources that we can give you to help you get free GED classes. But if you've done nothing in the next 3 weeks, again, it's not going to go well. I want you to become someone, not another statistic in and out of custody because you start doing things just to get money the wrong way. That's not the way to go through life. Who do you live with now? Your aunt. Okay.
She's here in the courtroom as well.
Great. Where is she? Come on up, ma'am.
I will say that when I mentioned to him that you have resources for a GED, he told me that he wanted to enroll in a program at a school because it was important to him to walk across the stage.
That'd be great. She can come. That's fantastic. That's what you need to do. I'm telling you, the more schooling you have, the more money you're going to make in life. Ask him. Ask him how great it is having money. He's killing it. And I'm telling you, this is your business model right here. Thank you so much for coming.
Yes, sir.
Thank you so much for taking care of him.
Yes, sir.
No, we want to see the best in him. And it starts with high school. So what I did was I made it a condition of his bond.
Okay.
And I will give you anything that you need also. What I told him is he's not allowed to smoke weed.
Right.
He's going to be tested again in 45 days. If he tests positive, I'm going to put him in jail.
Okay.
We have resources to give you if you need a phone, if he needs a tablet, resources to get a GED. We can help you out and we can give you these things.
Okay.
So whatever you need.
Thing today to try to make it right.
Right. So the other thing is this. I don't want you out in the middle of the night. Nothing good happens at 2 a.m. when you're out. Do you understand? What would you like from me? Do you need anything from me? I can put a curfew on him.
I've read the simulation that you already have, so we're gonna go with that.
Okay.
Yes, sir.
If you ever need anything, you can always come back here. We're happy to help you with whatever you need.
Yes, sir.
We're going to waive the cost on everything, so nothing's going to come out of your pocket for anything. Okay? And just good luck. Make me proud.
Yes, sir.
I'm asking much.
Thank you.
Okay. Good luck, guys.
Thank you.
Thank you. Mr. Lauderdale, you're charged with criminal mischief. You are facing up to a year in jail and/or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes. On January 3rd, 2025, the officer was dispatched to a gas station in Harris County, Texas, in regards to an assault in progress. The officer made contact with the complainant, and the complainant stated the defendant had damaged his vehicle that the complainant had parked his vehicle at the gas station by the front doors. As the complainant was in the store, he observed the defendant standing by the complainant's motor vehicle with a large rock concrete piece over his head, and the defendant threw the rock, breaking the front of the complainant's windshield, causing $1,000 in damages. The officer observed the large concrete rock sitting on the hood of the complainant's vehicle, and the defendant stated he was upset but did not elaborate.
Mr. Lauderdale, I'm going to find that there's probable cause to go forward with your case. You missed court, and I issued a warrant for your arrest. I'm going to recall that warrant now, but if you miss court again, it's not going to go well. Do you understand? Do you need a lawyer? Can I give you a lawyer? I need you to talk to me. Okay. I don't want you to pick up any new cases. I want you to be nice. Do not go back to this McDonald's. Do you understand? Do not go back to this McDonald's.
Your Honor, it's a gas station.
Oh, where is it?
Let's see.
I thought you said it was a McDonald's.
A gas station on Belfort Street.
Okay. Please don't go back to this gas station. Do not pick up any new cases. Do not be a danger to my public. Do you understand? Okay. So if you please provide him a lawyer. All right. I'm going to have you take a seat in the jury box while I find you a lawyer. Okay? Please. Be nice. It's not hard. Self-control. I've given you a lawyer. You have to stay in contact with him. If he tells me that he cannot get a hold of you, I'm going to issue a warrant for your arrest. Do you understand? Okay. Do you have any questions? All right. Do you have a cell phone?
Give me a phone number I can reach him on. His mother's.
Okay. Do you want a cell phone? We have services that we can give you so that you can get your own cell phone. Do you want one? Okay. Do you mind giving him, we're going to give you paperwork, but you have to do the work, but I'm going to give you the resources to be able to get a phone. If you need anything else, come back, talk to us, and we can try to give you whatever you need. The worst thing that can happen is that you don't come back. Okay? Perhaps we should do not waived. I don't know. It's up to you, whatever you think is appropriate. Okay? All right. Good luck.
Hey, Judge.
You were charged with assault, bodily injury. You're facing a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
My apologies. On June 29th, 2023 in Harris County, Texas, the complainant told his family of the incident, and the family reported it after it had happened. The complainant was with his friend, the friend's mother, and the mother's boyfriend on a trip to Galveston. The defendant became upset at the complainant because he did not like the way he was looking at him. The defendant pulled the complainant out of the car by his shirt, causing red marks on his chest. The defendant proceeded to slap the complainant in the face. The complainant stated he felt pain. Later on, while stopped at a gas station, the defendant became upset again, and the complainant began to walk away when the defendant grabbed the complainant's backpack that was on his back and threw him on the ground, causing pain. The complainant got up and ran away.
Who's that?
The complainant, a 15-year-old, I don't believe it was just a friend of the...
Mr. Chaput, I'm finding that there's probable cause to go forward with the case, and I'm ordering you as a condition of your bond not to have any contact with this person. Do you understand?
Yes, sir.
You're also not to be in possession of any weapons as well. If you violate these conditions, you pick up a new case or you fail to come again, I'm telling you, your bond will go high. I will protect my community at all costs. I don't care how old they are, how young they are. Do you understand?
Sir.
We've given you a lawyer. It is your responsibility to stay in touch with Hugh. If he tells me he can't get a hold of you because you're playing games, likewise, I'll issue a warrant. I'll have you sign a reset. After that, I'll have you meet with the pretrial, and then we'll get you out of here, sir.
Yeah.
Good morning, Mr. McCaskey. Thank you for coming a third time.
Yes, sir.
Listen, he's telling me that you're going back to Africa. You're going to go there for give or take a month. You're still under bond condition in this court. I'm ordering you not to consume alcohol, illegal drugs, unprescribed controlled medication. That's all we're having you do now. So even though you're over there, you're still not allowed to use. Typically, when we have people that go out of town, if they get called on the test, what we normally do is have them go to like a Quest diagnostic. They take a test, get the result to their lawyer, the lawyer gets to us. We'll still do things that way with you, even though they're over there. Normally, I pay for everything while you're here, but I can't pay for it over there. So you'll have to do it over there. And I don't even know if there'll be a Quest over there. You'll have to find something, I don't know. But you may not even get called, I don't know. It's the luck of the draw. I don't know.
Yes, sir.
The only other thing I'm going to tell you is that maintain contact with Mr. Henderson. Because if he tells me that you've gone AWOL, that he can't get a hold of you, you're gone, I'm going to issue a warrant for your arrest. And you, if you're out of the country and then we issue a warrant, I cannot tell you how big of a headache that will become. So always remain in contact with him.
Yes, sir.
Anything else?
Yes, that's it.
Oh, one more thing. You got to look, if you're going to drive over there, you got to look how to do it the right way. Because they don't play over there. You know, make sure that you have whatever documents you need. If you may need insurance, if you may need an international license, I don't know. All right? Okay. All right, guys. Good luck.
Thank you, Judge.
Oh, one more thing, sorry. Because you have him representing you, I will waive your appearance. You don't have to come to court here. But that's why I'm saying you got to remain in contact with him, and he'll tell you if and when you have to come back to court. Okay? Okay, that's it. All right, good luck. Good morning, Mr. Austin. Oh, I guess it's Mr. Rubio, not Mr. Austin. Right? Sir, you're charged with criminal trespass. You are facing up to 6 months in jail and or a $2,000 fine. You guys have worked out an agreement where they're offering you 13 days in jail with credit for the 21 days that you've done. You are giving up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization under federal law. You give up the right to appeal once you accept this. You can't change this. It's going to go on your record. From now on, you're facing a minimum of 30 days in jail. Do you understand?
Yes.
Is this what you want to do?
Yes.
How do you plead to the offense of criminal trespass? Guilty or not guilty?
Not guilty. Wait, not guilty.
Are you not guilty of this offense?
Yes. Yeah, not guilty.
Mr. Rubio, remember when he spoke?
Yeah, it's not guilty. Yeah.
Okay. I can't accept this if you're saying that you're not guilty. You know, this is what we do here is if you're guilty of this offense, then you plead guilty or whatnot. But if you're not guilty, then we can't do this.
Okay.
Remember what we talked about?
Yeah.
If you're not guilty, then you say not guilty. But if you're guilty, then you can take the plea.
What happened in this case?
So in this case, there was suspicious individual roaming the garage, and the witness, the Metro supervisor, stated she received multiple reports about an individual looking in the car windows and walking away when seen. The officer made contact with the defendant. The defendant was previously issued trespass warnings of the same property on August 14, 2024 and August 27, 2024. The defendant stated he had returned to park and ride because he has nowhere else to go.
So where was this location exactly?
A park and ride at 1030 West Grand Parkway.
Did you understand what
Yes.
they said?
Yes.
Based on what he said, are you guilty or not guilty?
Not guilty.
Okay. Can I talk?
Email?
Yeah, I will.
Okay.
Okay, Mr. Rubio. We're gonna go back. I'm gonna talk to you, okay?
All right.
Okay.
Miss Young,
Sir.
coming up.
Good evening, morning.
Don't look at his computer.
Sorry, I was trying to get the time from
How's jail?
evening. Sorry,
How's jail? Shh.
treating us beautiful.
You know, we can't get you to come. We can't get you to appear.
What happened was this time?
No, but there's always an excuse. It's really easy to just pick up a phone and call Josh. How hard is that? You know, that's all we literally ask you to do. Remain in contact with your lawyer. That's all you got to do.
Yes, sir.
We've repeatedly tried 4 different times. your lawyer's asking me to let you out to get in this program, but I know if I let you out, you're just gonna
No, sir.
take off.
I'll do the program. That's not the problem, sir. Honestly, with the phone situation, that's how he has a whole different number since last time I came. I don't even have that number anymore. And with the transportation part, I don't have a car. So the way I move around is either using the bus or my feet, sir. And last time that I did come, I came on my own. No one told me to come. No one called me. I knew I ended up
Don't
missing it
come
and I came.
Unless you're wearing orange. That's the only time we see you.
No,
You
sir.
don't-
I turned myself. I came in myself after I missed my court date, and I came in by myself. I can't give you a date, but if you look on there, I sat here and waited till everybody even left.
Guys, did she turn herself in or she got arrested? Can you tell? If you turn yourself in,
I
that
came
would
to
make me
court.
very happy. But if you just got arrested and that's why we have you,
No, sir. I came to court.
Young, she's on the jail doc. Last page, I think. Fool me once, shame on you. Fool me twice, shame on me.
I'm not trying to fool anybody, sir. Are you able to look that up for me?
It's okay, yeah.
Okay.
The date
Put it on there. Because it was like 2 days. Yeah, like it was 2 days after my court date. I came. No one called me. I just knew I missed it. And I didn't have a ride, but I made sure to get up there because that's how I got my date reset first time.
Looks like the booking date was the 12th, Judge, but I don't know. That's all I can see from my side.
That's when I came. So I've been here since.
Where did you come to?
Sorry?
Where did you go to? Did you turn yourself in the jail? Is that what you're saying?
Sir, I went to the Franklin Street, if I'm not mistaken, Franklin, 1200 Franklin, where all the court is at. Where I was supposed to go the first time. 1200 Franklin, if I'm not mistaken.
They said it was on Sunday, though. Was it over the weekend? They came.
Honestly, I don't even remember what day. This time? Yes, sir. I can't.
You know what we could do is we could do this, is that if we're gonna do this, you know how we do that release that we release to people? Something like that. So we know that she gets to the P180 place. Where is it? Where did they do the interview? Do you know?
I guess because it's not like an inpatient facility, would it be different if it's?
Where does it happen? Do you know? Do you know where the interview happens, Josh?
I'm not sure, like physically where it is, the P180. I'm checking the state though. Because I guess she wouldn't be released to that program. She'd just be released and have to.
Do you have a date already for it? Do you have a date for it?
There's like a way to book it online, but they said that you have to send the contract to PTI, P180 contract. So, which I think is what we have now. So I think we should be able to schedule it now.
Okay, so let's do this. Schedule it, get a date, and then I'll put a GPS monitor on her prior to release. I'm not going to do this again. You ever take off on me again, I swear on everything that's holy, that'll be the 5th time. Do you understand? So I'm not giving you a PR bond now. So just wait, get a date. We'll set it for like the day before, and then we'll give her a PR bond with a GPS prior to release. The instruction is she goes directly to get the interview done, and then we'll go from there. But I'm not going to continue to play this game.
But I'm not playing the game, sir. It's been cold. Like, what do you expect? It's been 20 degrees, sir. 20 degrees. You know how hard that is to actually stay.
Your finger's so frozen that you can't make a phone call?
Sir, I just got the phone. That's what I'm telling you.
If you need resources, we can give it to you. If you need a phone, if you need a tablet, if you need food, we have resources to give you. But you take off, you don't call, you don't come to court. So what are we supposed to think? And we just can't keep, I've got 4 different times. I can't continue to do the same thing.
We'll get this schedule.
Do it, we'll see. Okay.
Morning, Judge. We're approaching on Mrs. Troy Britton. This is the one that, oh, you weren't here yesterday, Judge. Judge Jackson was here yesterday. We were trying to do something, but I asked to bring my client here so she can know what's going on.
So Judge, the original approach yesterday, while Judge Jackson filled in, was the man jurisdiction requested an extension of 2 days, which she granted because it's 2 days and typically do that. But Ricardo wanted the accused to come so that it could be a more formal understanding of what's happening. And during that time for this morning, Ricardo's not telling me she is wanting to have a bond set by the court. State as opposed.
Yeah, this is the one where she's like 17 and she's got already like
she's had 7 charges,
Yeah.
2 of them
She's
failure.
19, Judge.
okay, 19. Right. Yeah. Sorry, I can't. Just you scare me, man. I can't. They're all very violent cases now. You know, you're wanted at state for another. You know, sorry.
Judge, if I may,
Sure.
in talking to my client, you know, she's made valid points to me. And of course, I'm just.
I know you're advocating for your client, and I'm never going to begrudge anyone for advocating. It's your job, I know. But you're 19 years old. You've got 7 priors already. You're wanted out of another state. There are multiple aggravated assault cases. You've got 2 failure to appears. At some point, we have to say when. And now's that point. You scared me, really. I don't want anything else to happen. So,
The extension was originally granted by Judge Jackson out to the, I want to misspeak, 24th.
I'm not doing any more. If they don't come here by that point, she gets released. Okay? All right. Thanks.
Thank you, Judge.
Mr. Barreño, you are charged with driving while intoxicated. First offense. Is it true or untrue that you had a breath alcohol concentration of a 0.15 or above? Okay, Trinity enhancement. You have worked out an agreement where they're offering you 1 year in jail to be probated for 15 months. As part of this agreement, you will do what's called a TRAS, which is an evaluation to see what other conditions you may need. You must fulfill any conditions that they add. 30 hours of community service, a victim impact panel. They have not put a DWI education class though. Did you forget to put a DWI education class?
See.
And is this a true first? Is it a true first?
It's a true first, Your Honor, and it appears that yes, we forgot to put the DWI education.
Let's do a DWI education class. 1 victim impact panel, no drugs, no alcohol, $250 in restitution to the complaining witness. You must have a guardian interlock and follow all other conditions of the court.
The guardian judge, I think we need a affidavit in order of ID.
You're on probation in this court. You need to understand that if you're not in this country with permission and you go to jail and immigration finds you, they're going to put a detainer on you. So if I were you, while you're on this probation, I would live with a halo above my head. Follow all the conditions. Do not consume alcohol. Do not drive. It is a part of your probation. If you violate these conditions, I'm going to put you in jail. I will issue a warrant, put you in jail, and I'm going to bring you out. We're going to have a hearing as to whether you violated it. If you do, you're looking at an entire year in jail. Do you understand?
Yes.
You also need to understand that from now on, you are facing a minimum of 90 days in jail for any new cases that you pick up. You are giving up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization under federal law. You give up the right to appeal. Once you plead guilty, this is going to go on your record. It's going to be there for the rest of your life. You can never take it off. Is this how you understand the agreement?
Yes.
How do you plead to the offense, guilty or not guilty?
Guilty.
I'm going to find you guilty. One more caution word is that because this is going to go on your record, if you were ever pulled over, even 30 years from now, an officer sees this and they smell alcohol on you, it's probably not going to go well. Good luck, sir.
You guys already, Judge.
Okay, so whatever. Okay, good luck. You wave the sheet. All right, ready?
Yes, sir.
Oh, I'm sorry.
It's because we have the interpreter here. It's a Spanish plea also for Pichu.
He's pleading on both, huh?
Yeah, he's got to play on both. They got him in it.
Mr. Perechu, today is not a good day. You were on bond for a DWI. You picked up another DWI. You've been able to work out agreements with both of these, but both of these charges will go on your record. They will be there for the rest of your life. You need to understand, if you ever pick up another DWI, you will be facing a third-degree felony, a minimum of 2 years in prison, a maximum of 10 years in prison. If I were you, even if you have had a sip of alcohol, I wouldn't get into a car. It is a humongous risk that you're taking. Do you understand?
Yes.
You are giving up the right to a trial, right to compel witnesses to testify on behalf, confront and cross-examine your accusers. If you are not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization under federal law. You give up the right to appeal, so once you plead guilty, you can never take these off. Do you understand?
Yes.
How do you plead to the offense? Guilty or not guilty?
Guilty.
I will find you guilty. On one of the cases, it's alleged that you had a .15 or above. Is this true?
Yes.
Okay, true to the enhancement. All right, I'm going to suspend your license for a year. Do not drive. Good luck to you, sir.
That's the only thing you have with those.
I'm going to waive the fees.
You will.
Waive the fees? Is that what you're talking about?
Okay, thank you, Judge. Appreciate it.
Good morning, Mr. Harris. Sir, you were charged with assault of a family member. You're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
This case on docket, or is it?
No, it's a walk-in.
May I get the cost number?
Yeah, it's too fun. Go ahead.
And then after I said, I need to pull it up, it's 254, counsel. 5144.
Thank you so much. On December 27th, 2024, in Harris County, Texas, officers were dispatched to a family disturbance call, and upon arrival, the officers met with the complainant's son, who stated that his parents were fighting. The officer met with the complainant, who was not cooperative, but stated that the defendant choked her, causing pain, and reported pressure of a 7 on a 1 to 10 scale. And then the officer then observed a large bruise on the complainant's arm. The complainant's son stated that the defendant had abused the complainant for a very long time, and that this is not the first time he has choked her.
Mr. Harris, I'm going to find that there's probable cause to go forward with the case. I'm ordering you as a condition of your bond not to have any contact with the complaining witness in this case and not to be in possession of weapons. Do you understand?
Yes, sir.
I'm entering in now what's called a magistrate's order for emergency protection. That is a court order that identifies Ms. Pisana as a protected individual. You cannot commit family violence or an assault against this person. Commit an act in furtherance of an offense under section 42.072 of the Texas Penal Code, which is the stalking statute. You cannot stalk, threaten, harass, use another person to communicate a threat or harassing behavior, be in possession of a weapon, or go within 200 feet of the Buffalo Bend Drive address. Do you understand?
Sir.
If you violate this, the state can and probably will file a violation of protective order. It's one of the worst cases you can pick up. Do you understand?
Sir.
Okay,
Can I speak with you?
please.
The state has had a chance to talk to the complaining witness this morning and on January 2nd, and the complaining witness spoke with officers at the time of the investigation and said that she did not want to press charges, that they had a dispute and that it was not, as talked about by everyone else, she was not saying to anyone that she was choked or anything else. And they spoke with her this morning. She only wants a protective order against violence communications between each other. They've been married for 7 years, together for 19 years. They were together as much as yesterday, Your Honor, and that's not what she's looking for. She's looking for resolution of the case. They have a home together, they live together, raise their children together. Mr. Harris has been employed at the same company doing construction work for the last 20 years. They're fighting a foreclosure on their home. Having him move out to try to find somewhere else to live would make them keeping their home impossible.
My only concern is the violence. And my major concern is the fact that we have here children that are exposed to and see continual violent behavior, you know? When a kid sees that, what happens? You know, that's a huge concern. Did the child say that this happened?
No, said it's not the first time.
Well, the son was not present at the incident. I think.
Well, I don't know that.
Yeah, that's the thing.
I mean, all I know is that a child telling an officer, hey, man, you know.
Son is 18, does not live in the residence, came to the residence as they were getting into it. So would not have been there, would not have saw interaction with him. But the facts will lay themselves out, and we'll look to that, Judge, but we are asking the court would consider that.
Guys, what do you say? You heard the facts, right? He wants to have contact.
I just spoke with the complainant and she requested no negative contact. I gave her the options of no negative or no contact altogether, and she said no negative.
So you think contact's okay?
I would defer to you, Your Honors, that's what she said, but no contact, the more restrictive is fine with us.
What scares me is that even, you know, they're going through even a more stressful time. You know, if their house is in foreclosure, it adds upon more stress. So we have these facts that are pretty bad. We've got more of a stressful situation happening now. The last thing I need or want is for anyone to end up on the news because someone does something rash that you can't recover from. You know, the thing is that when you pick up these criminal cases, right, you've dug yourself a hole, but the hole is not so deep that you can't get out of. Sometimes people dig themselves such a damn big hole they never get out of. It's continually on the news every single day. 90% of the people that you see in jail, because they don't have any self-control. They get upset, they wig out and do whatever the hell they want to do without thinking, if I do this, what's going to happen? If I say this, what's going to happen? Because when stuff of this nature happens, it affects everyone. It's like a cancer. It radiates everywhere and affects everyone. And with the stressful things that are going on now, it scares me to allow contact because I don't want any further. I don't want anything worse to happen. I don't know. I don't know.
I understand, Judge. Mr. Harris has no criminal history. This is the first allegation. I know what we hear in the office report about it happening fast. We've never had any action with law enforcement in something like this. I don't have any doubts. I've known Mr. Harris and his father for many years now, and I don't expect anything to happen, but you're right. I can't stand before the court and say that. And Mr. Harris can do everything that he can do to ensure he's used coping techniques. We've talked about him since I've been representing him about leaving the scene. It's not in the report, Judge. There's some things that we have to deal with, alcoholism within the home, that he's trying as a husband to work through with his wife. So there's some things that need to be done, Judge, but he's been responsible.
That's the other thing I was going to say is I don't want you consuming alcohol or illegal drugs. I'm going to test you. If I find that you're consuming alcohol or illegal drugs, you pick up a new case, I'm going to put you in jail. I'm going to tell you now, I will do everything in my power to protect my community at all costs. I don't care who is in front of me. I don't care what gender, color, or your small farm animal. I don't care. Do you understand?
Sir.
The problem is that, and what you need to understand, what is threatening or harassing doesn't matter what you think. I could care less what you think. It is what the other person perceives. So can conduct alone violate this? If I go like this, is that threatening or harassing? It most certainly is. And they can land your butt in jail in a moment's notice. Do you understand?
Sir.
How long ago did this take place?
December 27th.
27th of 2024, yeah.
So it's been a couple weeks already.
A couple weeks already.
I will allow you to have contact, but no threatening or harassing contact. And I'm telling you now, between now and the next setting, I'm going to test you for drugs and alcohol. And if I find that you're using, I will lock you up. You have to imagine that if you're in jail and the bond is set at 10 to 20,000, if you don't have anyone to pony up that kind of money, you will be stuck like Chuck until this thing's over with. Do you understand?
Sir.
Self-control. We all get upset. I have 4 kids. They drive me up that freaking wall every single day. If I try to beat them into submission, it only makes things worse. Because hell hath no fury like a scorned woman and a teenager who's out of control. And when they see that type of what's going on, it's okay. They think it's okay. It's not.
Understand.
All right. Okay. So you will be monitored by trial. No threatening or harassing. He can go back home for now. But if I hear anything else, I'm going to unleash. Do you understand?
Sir.
Okay.
All right, will we get excuse for him to give a pretrial bond?
Oh, yeah.
He's a lot set, and I'm hearing no updates.
No what?
No more?
No. The MOAP's going to be granted.
Okay.
I'm entering in the order for protection. Everything in that order is stuff that you shouldn't do anyways. The only thing I'm taking off is the residential restriction. Everything else stays. So if you make any threats, they're going to file another case on you. And I'm going to tell you, it's the capital murder of misdemeanors. You pick up a violation of protected order. Does he have any criminal history? All right, I'll set bond at $100. I'll grant you a PR bond. It's the only one you're going to get, though. You understand? Okay, guys. Got it. You died. Thanks. Good morning, guys.
Yes, sir.
Both of you guys are charged with criminal cases. Both of you guys have worked out agreements with the state to plead guilty on those cases. What you guys need to understand is that they will end up on your record. They're going to be there for the rest of your life. You can never take it off. They're even there after you die. This is important because from now on, you will have minimums for any new cases that you pick up, if you pick up cases. So for both of you, Mr. Esparza, you're charged with criminal trespass. You're facing up to 6 months in jail and or a $2,000 fine. The agreement you have is 3 days in jail, credit for the 6 that you've done. From now on, any new cases you pick up, you're looking at a minimum of 30 days in jail. Do you understand?
Sir.
Mr. Wardy, you're charged with assault causing bodily injury, and that's a Class A. You're facing up to a year in jail and or a $4,000 fine. You pick up any new cases from now on, that's a minimum of 90 days in jail. Do you understand?
Yes, sir.
Both of you guys are giving up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers, right to be arraigned, charged, read in open court if you're not a citizen. There are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. How do you plead to the offense, Mr. Wardy?
Guilty.
How do you plead to the offense?
Guilty.
I'll find both of you guilty, sentence you to the time, and roll your court costs. Good luck to you.
Yes, sir. Thank you.
Mr. Barnes, you were charged with theft. We're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
On April 8th, 2023, the officer was dispatched in reference to theft. The officer made contact with the complainant, the Walmart store manager, who stated that on April 7th, 2023, the defendant grabbed an iPhone 14 Pro Max, placed it under garments, walked to the men's room, and returned to the sales floor, where he passed all points of sale without attempting to purchase. The value of the item was $1,000 and 149 cents, or $1,149. And the complainant stated that he went into the men's room and found the iPhone 14 casing and wrapper in a garbage can. The complainant stated that they did an audit on the cell phones and noticed one missing. And the complainant stated the defendant was observed on surveillance taking the phone, and the defendant was brought into the office and questioned about the phone, where he admitted to taking the phone. The defendant further admitted to unwrapping the phone in the men's room and then taking it home. The officer made contact with the defendant, who repeated that he took the phone and passed all points of sale.
All right, Mr. Barnes, I'm going to find that there's probable cause to go forward with the case. I will give you a PR bond now, but if you pick up any more cases, you do anything else, no more. Do you understand?
Yes, sir.
How old are you, sir?
22.
Okay. What do you do for a living?
I'm a sales representative. But,
Graduate
I don't
high
have...
school?
Sir? Yes, sir.
Graduate from high school?
Yes, sir.
Okay. Let's do this. I'm going to appoint you a lawyer today. As a condition of your bond, you're not to go to any Walmarts. Do you understand?
Sir.
Just be good. This is literally one of the worst that you can pick up, man. Really. You're 22. You're starting life now. You build yourself up, not down. Now, theft is... I'm not going to Walmart.
Yes.
All right, so I'm going to have you sign a receipt of the Victoria, and then I'm going to have you take a seat. Find your lawyer, okay? Extremely important. If you fail to register on your release from jail, they can potentially file felony charges on you. Do you understand?
Es que sí o no. Yes.
Yes.
So we need him to sign paperwork reflecting that he's been admonished about the registration
Yes, sir.
requirements. The agreement that you have worked out is 250 days in jail
Yes.
with credit for the 130 days that you have done.
Y ya sirvió.
You give up a lot of rights by entering into this agreement, Mr. Bonilla. You give up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you are not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization under federal law. You give up the right to appeals once you accept this agreement. You can never change this or undo this. Do you understand?
¿Lo entiende?
I understand this.
You still want to do this?
Yes.
How do you plead to the offense of indecent exposure? Guilty or not guilty?
¿Culpable o no culpable?
Culpable.
Guilty.
I will find you guilty, sentence you to 250 days in jail, give you credit for the 130 days that you have done.
Ya sirvió.
I need to see if it's enhanced. It is enhanced. Mr. Bonilla, you were enhanced with a Class A misdemeanor assault out of Court 5 from February 6th of 24. Is it true? Is it true that you
¿Verdad?
had that prior assault?
Ese asalto previamente.
Did you have a prior assault with us here?
¿Y en esta corte?
Yes.
Yes.
So true to the enhancement. Is that it?
I'm gonna have them fill this out, but that's turning out to go over and show them.
Okay, so, okay, but we need you to go with this over with him so he can initial it. He initials by everything, and then I'll sign it after the fact. Okay, all right. We're Mr. Gil Rodriguez,
Rodriguez?
and you
Yes.
are Mr. Ventura.
Ventura?
Sit.
Yes.
Both of you have picked up criminal cases. Both of you have worked out agreements with the state of Texas. You need to understand that the agreements that you guys are working out today will reflect as convictions on your record. Once you plead guilty, there's no turning back. It will go on your record and it will be there for the rest of your life. You give up many valuable rights by entering into this agreement. You give up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you are not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization under federal law. And like I told you earlier, once you plead, it's there forever. It's even there after you die. You can never take it off. Mr. Gil Rodriguez, you are charged with assault, bodily injury. You're facing up to a year in jail and or a $4,000 fine. The agreement you've worked is 7 days in jail. Credit for the 7 days that you've done. Is this how you understand it?
I understand guilty.
All right, I'm going to find you guilty. I will follow the agreement, send you to it. I'm going to tell you now that any more cases you pick up, you will be facing a minimum of 90 days in jail. No more proverbial slaps on the wrist. Mr. Ventura Lopez, you were charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine, and you've worked out an agreement where they're offering you 6 days in jail with credit for the 2 that you've done. Understand by pleading guilty to this offense from now on, you will be facing a minimum of 30 days in jail. You understand?
Yes.
This is what you want to do.
Yes.
How do you plead to the offense of driving while intoxicated? Guilty or not guilty?
Guilty.
I'm going to find you guilty, sentence you to the agreement. I'm going to tell you now, anytime you get pulled over, officers will look at your record. They're going to see that you have a prior DWI. If they come up to your car, they smell alcohol on you, it's probably not going to go well. If I were you, for the rest of your life, if you want to get lit, don't get into a car because it's a humongous gamble. I'm suspending your license for 90 days. Do not drive until you get a license. Yeah, you're appointed on the case?
I am, Judge.
Okay. I'm going to tell you one more thing, that DWI is big business in Texas. There is a $3,000 surcharge that normally we would tack onto this. On a second DWI, it is a $6,000 surcharge that you can look forward to on another one. So be careful, don't come back. You are wanted out of the state of
Pacific. For a burglary, Your Honor.
for a burglary charge. Your lawyer is asking me to set you a bond. I don't know. You know, one of the main things are you a danger to my community? Because if you are, it's just not going to happen. I'm going to do everything in my power to protect my community at all costs. You know, I have a lot of people that tell me, you know, little bunnies jumping in the woods, that's who they are. But when I look on paper, they're a completely different person. Mr. Kim, would you mind telling us about Ms. Hale, please?
Yes, Your Honor. She's currently also being held in the 182nd for second-degree level of possession of a controlled substance. She was recently convicted in Galveston County for a deadly conduct charge that was initially pled as an aggravated assault with a deadly weapon, along with a burglary habitation that was dismissed, presumably with a plea deal. She was also previously charged with possession of a controlled substance that was dismissed earlier last year as well. She was previously a fugitive, charged as a fugitive in the 90s, along with a few other charges from Mississippi, 2 charges of larceny, 1 charge of grand larceny, and obviously these offenses.
Yeah, I don't, it's too much baggage, man. You know, and especially you also telling me that this case is over a year old.
Or the warrant deal was, that one was issued out on January 10th, 2024, Judge. So it's been 1 year.
Do we know if she knew about it?
That I wouldn't be able to say. I don't know if it's an FTA, Judge. I can find out, but I don't know the answer to that point. It typically says, it just doesn't say.
Here's the deal. If I were to set you a bond, you would have to make it. I think you would have to make all of it. It's not something where you can pay the customary 10% because you're an inherent flight risk and you have a prior fugitive case as well. You know, I don't think, I'm not going to set you a bond, man. You just got way too much baggage. You have a prior failure to appear. This case is a year old. You've got a second-degree felony. Is it with intent to deliver?
No, Your Honor, it's just the amount for it.
It's just too much, ma'am. I'm sorry. So the deal is this, is that you have 2 choices now. You can waive extradition, which in this case, normally what happens is we give the other jurisdiction 14 days to come get you. And if they don't come get you, Harris County releases the hold. But for that to happen, you have to make bond on the felony case. Because you have not made bond on that case there, it's kind of in a holding pattern until you either take care of that case or you post bond on that case. If you post bond on it, that will get the 14-day to start kicking. Okay?
She's already signed a waiver, Judge.
Oh, she's waived.
Under the Met.
Oh, okay.
Already, Judge.
Got it. Okay. But just to give you information, I don't know how much you know or not, but right now we're basically in a holding pattern anyways, just because you've not made bond on that case. Okay? If you don't understand, I can have Shelby tell you more about it so that you can get a good grasp on what everything is. But understand, it's just too much baggage, man. Okay? All right. Thanks. Thank you. I'm ordering you as a condition of your bond not to go back to any HEB. Do you understand? If you violate these conditions, you pick up a new case, I'm going to put you in jail. No more PR bonds. You understand, sir? Are you working now? Do you have an income?
I am studying for my board exam. So no,
Studying for board exam for what?
actually,
Really? Not a good way to start, sir. You know, really. Look, I'll give you a lawyer today. Don't pick up any new cases. You got to understand that you got your future ahead of you, man. You want to be a nurse and now you got, come on, really? I need you to fill out an application for me. Fill it out. Let me take a look at it. I'll give you a lawyer today. Just make smart moves. It's not hard, you know, really. Come on. You are Joaquin Hernandez.
sorry.
Mr. Hernandez, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge. On January 12th, 2025, the officer was dispatched to 7000 Gulf Freeway and another officer had advised that the defendant was asleep in the driver's seat of the vehicle. The vehicle was on and running, and the officer observed a container of beer in plain view in the center cup holder. The officer made contact with the
Drinking while driving?
Yes, Judge. And the officer observed a strong odor of an alcoholic beverage, watery bloodshot eyes, slurred speech, and the defendant admitted to consuming beer, but did not state the amount. The officer observed a 12-ounce Michelob Ultra cold to the touch and a plastic bag labeled Margarita to go with a straw sticking out of it, mostly consumed, and an open pack of beer in the back seat. The center filtered writings were performed, HGN 6 out of 6. Walk and turn and one leg stand were not performed due to the defendant claiming he had one bad leg. The defendant was read the DIC and declined to provide a sample, and a blood search warrant was signed and executed.
Mr. Hernandez, I'm going to find that there's probable cause to go forward with your case. Can you see if he has any prior DWIs, please?
Yes, Judge. I see no prior DWIs.
I would venture a guess that it's damn elementary that you're not supposed to have alcohol in the car. I am now taking away your privilege to drive. You will be signing an affidavit with me today, promising you're not going to drive, and I don't give a rat's behind what is going on in your life. If I find that you drive, and I don't care if there's a burning building and you have to save 50 children, I can have a contempt hearing. And every time you drive, you can be facing up to 6 months in jail and a $500 fine. Do you understand? Do not drive for any reason. If you have a problem with drugs or alcohol, you better address it, because if you don't, I will do it for you. And I promise you're not going to like the way that I do it. I'm ordering you not to consume alcohol, illegal drugs, or unprescribed controlled medication. If I find anything, you're going to stay with me. No more PR bonds.
Will he have the opportunity to have an interlock system on his vehicle?
No, he can't drive. I'm not going to let him drive. I mean, he's got multiple open containers, all have consumed allegedly. No. I mean, and I would think that, it's a privilege. And if I get that he understands the awesome privilege at a later date, come back and we can talk. But at this point, no. I will have you come up here, swear to us that you're not going to drive. After that, I'm going to get you the Victoria sign and reset. After that, what is your name, please?
Katia Smith.
I'm sorry?
Smith.
Ms. Smith. You will get to Ms. Smith where she will give you your bond conditions. After that, you'll be free to go. Because you have a lawyer, I will waive your appearance, but it is your responsibility to stay in touch with them. If they tell me they can't get a hold of you because you're playing games, you pick up a new case, you endanger my public, I'm going to revoke your bond and I'm going to put you in jail. Do you understand? It's not hard.
Chad, when we return on March 19, is there a possibility that we can present evidence to the court to permit the interlock?
I am always all ears, but at this point, with all that's in that car, no. But come back at a later day, show me, because it is a privilege. It's not a right. You want a right, take your Dodge Patas and take, but it's an awesome privilege, and that's what it is. Show me how much of an appreciation, proactivity goes a long way, and then we can talk. All right? Yes, ma'am. Are any of you here with parents today?
No, sir.
Were you Mr. Gamero?
It's me.
Mr. Gamero, you were charged with unlawful carrying of a weapon. You are facing up to a year in jail and or a $4,000 fine. Mr. Garcia, you were also charged with discharging a firearm in a metropolitan area. All of you are facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You each have the right to have an attorney present. If you cannot afford one, one will be appointed to you.
On January 12, 2025, the officer observed 4 males in dark clothing forming a circle and discharging several high-caliber weapons into the air while on patrol behind a residential neighborhood in Harris County, Texas. The officer observed 2 males run towards Muscatine Street and 2 males flee towards Garber Lane, where the officer remained stationary. The officer identified the second male apprehended as Defendant Gamero, 18 years old, who was found in possession of a Glock handgun tucked into his waistband. Defendant Gamero admitted that he and a co-defendant, a 14-year-old juvenile, had been firing an AR-15 and a Glock along with 2 other males who fled with a second AR pistol, and the other 2 males were apprehended, one of which was Defendant Gallegos, 17 years old. Defendant Gallegos confirmed the other male's identity and stated the weapons had been passed around among 4 individuals and that all were involved in shooting them, and that the AR was purchased from an unknown individual in the street. The 4th male was identified as Defendant Garcia, 17 years old. Defendant Garcia admitted to firing all 3 seized weapons, and Defendant Garcia was observed disposing of an AR-15 and surrendering.
Gentlemen, I'm going to find that there's probable cause to go forward with each of your cases, and I am ordering you as the condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. How old are each of you? How old are you, sir?
17,
How old are you?
17,
How old are you?
22.
What do you do with yourselves?
Well, I just be at the home with my girlfriend.
Did you graduate from high school?
No, sir.
We're going to work on that. Did you graduate from high school?
No, sir. I'm 12th grade. Yeah.
Are you currently enrolled in school?
No, I had dropped out, but
Hey, not anymore.
this,
We're going to work on that. What's your situation?
I'm currently enrolling in school because I just left and
No. Are you enrolled or
No,
are you
sir.
not? Okay, we're
Alright.
going to work on that as well. Did you graduate? We're going to work on that. The first thing I'm going to tell each of you is that you are not to smoke any weed. I'm sending you each for a test right now because I want to know what, if anything, is in your system. If there's something in your system, you will get a pass today. But I'm giving you notice now that you will be retested in 45 days. And if I find that you continue to use, I'm going to put you in jail. I don't know if you're using, but if you are, it stops today. And if you stop today, in 45 days, you will be clean. If you continue to use, you're going to end up staying with me. Do you understand?
Yes, sir.
What goes up must come down. So when you fire a gun in the air, a bullet has to go somewhere. If it lands on a 7-year-old's head, what happens? It's a rhetorical question, meaning that you don't need to answer. But I'm giving you something to think about, that what goes up must come down. What goes down will ricochet. And if it ricochets into a person, someone's going to get charged with that murder. Do you understand?
Yes,
There
sir.
are proper places to do these things. That's what you do. As far as I'm concerned now, none of you are to be in possession of any weapons whatsoever. Don't worry about filing any conditions because each of them are going to be honored. I will provide each of you guys a lawyer today, and I'm going to send you for a test. You must come back. If you fail to go test, if you fail to come back, I'm going to issue a warrant for your arrest. Do you understand?
Yes, sir.
Okay, take a seat for me, please. Mr. Gallegos,
Page 3.
this is not a good way to start in life. I can tell you now that if you don't have a high school diploma, you will make pennies to when everybody else is making dollars. You will never have a good job in this life at a minimum without a high school diploma. Knowledge is power. And if you don't set yourself up for something in the future, you're going to end up destitute. 90% of the marriages that are end up in divorce now is because people have no money. They fight constantly because they never have money. And it all starts now when you're 17. And it starts by staying in high school. I want you to do that. I'm going to bring you back in 2.5 weeks. I want to see what you have done to get back into school. If you need help, I can give you resources so that we can sign you up for free GED classes. Because I don't know if you're old enough to get back into high school. But if you want, I can give you resources now so that you can start with GED classes. That's fine with me. One more thing. No smoking weed. I will test you 45 to 50 days from today. If I find that you're smoking weed, it's not going to go well. You get my drift.
Yes, Your Honor.
If you stop as of now, the next time I test you, it should be negative. If you continue to use, you understand?
Yes, sir.
You must stay in touch with Ms. Oakforth. She'll tell you how to handle this case and what you need to do. If she tells you that you're playing games, I'm going to put you in jail. No more PR bonds. All right? You understand?
Yes, sir.
Good luck, man. Make me proud.
Javier Gamero.
Come up, sir.
I've been informed by pretrial services that enforcement tested positive for marijuana.
Okay.
Thank you. This is first time.
Come up. What happened to the third kid?
Let me just.
He hasn't made it back yet.
Okay. So, no more.
Yes, sir.
You're not to. I'm going to test you again in 45 to 50 days. If I find that you're using, it's not going to go well for you. If you stop as of right now, in 45 to 50 days, you should test negative. If you keep smoking, it's not going to go well for you. You also need to get back into high school. This is not a good way to start in life. If you need resources, we have it for you.
I don't got my diploma, but I got my certifications to like work at the refineries. So I can even work.
You need your high school diploma, man. That's what I'm trying to get you to do, you know? And I have free classes for you to be able to do it. And I can give you the paperwork, so it's not going to cost you anything. But at a minimum, if that doesn't work out for you, you need something to fall back on. You know what I mean? All right. We're going to give you that paperwork. I'm going to bring you back. I want to see that you're doing well. All right? Okay, man. No more smoke. Okay. All right. Morning, Mr. Garcia. Sir, you were charged with unlawful carrying of a weapon. You were facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge. Okay. On January 9th, 2025, officers were dispatched to a disturbance with a weapon at a Boost Mobile business in Harris County, Texas. The officers were advised that 2 suspects were trying to rob the store, one with a handgun and in a wheelchair. The officer observed the male matching the description inside the business, and the defendant turned as if he was going to leave. The officer asked the defendant if he had any weapons on him, and the defendant stated he did not have any weapons and that he was confused as to what was going on. The defendant agreed to the officer patting him down for weapons and immediately began reaching into his pockets, claiming he was going to retrieve his wallet. The officer observed the defendant to have an unholstered black handgun on the right side waistband tucked between his shorts, and the defendant claimed the handgun was his sister's, was borrowed for safety, and the holster was in his sister's car.
So you said they were robbing the place and
He was reported to be involved in a robbery, and that's what the officer was.
they charged?
They charged him with, no, just the possession of PCS and then the unlawful carry.
Mr. Garcia, I'm going to find that there's probable cause to go forward with your case. I'm ordering you as the condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. If I find that you're using illegal drugs, any kind of alcohol, I will put you in jail. No more PR bonds. As it stands now, you're on felony probation. You've now picked up a case with us and you have a felony possession case. Is there a co-defendant in this case?
Yes, Your Honor. There actually, no, Your Honor, there's not.
You said
they allegedly had 2 suspects, but the officer only made contact with the one defendant.
You're not to be in possession of any weapons, no alcohol, no drugs. Do you understand?
Yes, sir.
Tell me, do you need a lawyer appointed to you today?
Yes. I'm getting one, but not right now.
I can go now if you want. Don't pick up any new cases. Don't be a danger to my community, Mr. Garcia, because I'm going to tell you now, I'm going to protect
I was
my
buying a phone.
Stop. Don't say anything. Just, I want you to know that I'm going to protect my community at all costs. Do you understand?
Yes, sir.
I don't know what happened. I wasn't there. We got to wait for the evidence to come in. That's going to show us whose side is correct. I don't know. We'll get there. But just while you're out there in the free world, make the right moves. Because if I see you making wrong moves, I have only one place for you. You understand? Can you reach out to the Mac for Mr. Garcia, please? All right, so for now, I'm going to have you sign a reset with Victoria. We'll have you get with Ms. Smith for your bond condition, and then I'll have you take a seat in the jury box. You were Ms. Tijerina.
Yes, sir.
Ma'am, you're charged with driving while intoxicated. Second offense, you are facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, ma'am.
Yes, Judge. On January 11th, 2025, the officer observed the defendant's vehicle bearing an unreadable E-tag at the 6900 block of Spencer Highway. A traffic stop was conducted and the officer made contact with the defendant, the driver of the vehicle. The defendant stated she was aware the E-tag was unreadable as it was waterlogged from being so old, that the E-tag was expired as of November 2024, and that her license plates were at home but not yet on the motor vehicle. The officer confirmed the defendant was operating the motor vehicle with the wrong license plates and observed no proof of financial responsibility for the vehicle. The officer observed slurred speech, red glossy eyes, and a strong odor of an alcoholic beverage. The defendant stated she was coming from a local bar, had consumed a bucket of Michelob Ultra beers, and standard fields of writings were conducted. HGN 6 out of 6, walk and turn 3 out of 8, one leg stand 3 out of 4. The defendant was read the DIC and attempted a breath. The defendant attempted to provide a breath sample but was unable to complete the test. A blood search warrant was signed and executed.
Did you say she did field sobriety test or no?
She did. Would you like me to read them again?
Yeah.
HGN 6 out of 6, walk and turn 3 out of 8, and one leg stand 3 out of 4.
Ms. Tijerina, I'm going to find that there's enough probable cause to go forward with your case. Can you see if she has a valid license?
It's elsewhere on.
Okay, I'm now placing a restriction on that license. Don't get in trouble. Make wise decisions, because if you don't, there will be disastrous consequences. And while you're out there, if you're driving, you're not allowed to unless it has an interlock on it. Do you understand?
Yes, sir.
Okay. So yeah, let Ms. Smith know about the travel, so that way.
Right. I don't want her to get
knows.
violated this.
So you have a lawyer. Because you have a lawyer, I will waive your appearance. You don't have to waste your time coming to court, but you must stay in touch with Casey, and she'll tell you when you have to come back to court. If she tells me that you've gone AWOL, she can't get a hold of you, I'm going to revoke the bond. Do you understand, ma'am?
Yes, sir.
All right. I'll have you sign a receipt with Victoria. We'll have you get with Ms. Smith for your bond condition, and then you're free to go. Thanks, guys.
Thank you, Judge.
You are Jorge Gomez.
Sir, I am.
Mr. Gomez, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
Yes, Judge. On January 12th, 2025, the officer was dispatched to the 6800 block of Highway 225 within the city limits of Deer Park for a sedan stationary in lane 2 with a missing front tire. The officer observed the defendant in the driver's seat slumped over, the vehicle to be in drive, and the defendant to have his foot on the gas. The officer observed damage to the front right of the motor vehicle and the front right tire to be missing. The officer had to force entry into the vehicle to check the defendant's welfare due to the vehicle being locked. The officer put the vehicle in park and turned the vehicle off. The officer called out to the defendant, shook his arm, and administered 4 to 5 sternum rubs, and the defendant then slowly woke up and was unaware of what was occurring. The officer observed slurred speech, red glossy eyes, and a strong odor of an alcoholic beverage, in addition to unsteadiness on the defendant's feet. The officer observed a buzzball chiller and beatbox alcoholic drink on the front passenger floorboard, both containers empty. The defendant stated he drank 6 beers earlier in the night and thought he was still in Houston. Extended field sobriety were administered, HGN 6 out of 6, walk and turn 6 out of 8, one leg stand 3 out of 4. The defendant was read the DIC and consented to provide a blood sample.
Are you telling me that there was alcohol while he was driving?
They just found empty containers. There's no facts indicating.
Okay. Does he have a valid taxi driver license?
All right, Your Honor.
Please. And any prior to BIC can run an NCIC. Mr. Gomez, I'm going to find that there's enough probable cause to go forward with your case. I'm ordering you as a condition of your bond not to consume alcohol or illegal drugs. I'm going to randomly test you. If I find that you're using, I'm going to revoke your bond and we'll put you in jail. No more PR bonds. Do you understand?
Your Honor, no prior DWIs and life is eligible.
If you don't have liability insurance coupled with that license, then you're not allowed to drive. That's also a condition of your bond as well. Do you understand? Do you have the ability to hire a lawyer?
No, sir.
Do you want to apply for an appointed lawyer?
Sir, the thing is, I'm actually on probation for a different.
Stop. Just don't. All I want to know is you want a court-appointed lawyer.
Yes.
Okay. I'm going to appoint you a lawyer today. Just don't say anything. I've got a bunch of DAs here. Whatever they say, they can use it against you. I'll have you sign a receipt, Victoria. We're going to give you an application. You will eventually meet with Ms. Smith, and then we'll appoint your lawyer.
Yes,
okay?
Good morning, Judge.
Hi.
How are you, sir?
You standing in for Mr. Butler?
I'm standing in for Mr.
Okay,
Butler.
wonderful.
I'm a MAC attorney as well.
Okay, great.
Okay.
Thank you.
Good to see you.
Okay. Good morning, ma'am. Ma'am, you're charged with you are Ms. Greeny. Okay, Ms. Greeny, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, ma'am.
Yes, Judge. Okay. On January 9th, 2025, the officer was dispatched to 1100 Siegler Road regarding a major crash, and the officer observed the defendant outside her vehicle talking to Houston Fire Department. The defendant's vehicle was in a ditch with apparent minor front end damage, was on and in the in-park position. The defendant appeared disoriented, had poor balance, and was not able to stand unassisted. The defendant stated she had the motor vehicle's key fob in her pocket, and the defendant was taken to HCA Healthcare, and the officer then went to HCA to obtain a statement. The officer observed a strong odor of an alcoholic beverage and bloodshot eyes. The defendant stated she did not strike her head or lose consciousness due to the collision and drank between 1 to 10 12-ounce Miller Lite beers prior to operating the motor vehicle and getting into the collision. The defendant further stated she could not remember the time she drank her last beer. Standard field sobriety tests were administered, HGN 6 out of 6. Walk and turn and one leg stand were refused as the defendant stated her balance has always been bad. The defendant was read the DIC and a blood search warrant was signed and executed.
All right, ma'am, I'm going to find that there's probable cause to go forward with your case. I'm ordering you as a condition of your bond not to consume alcohol or illegal drugs. I'm going to randomly test you. If I find that you're using, I will revoke your bond, put you in jail. No more PR bonds for you, ma'am. Any priority to BIs?
No, Your Honor. And your license is eligible.
You have a lawyer. Because you have a lawyer, I will waive your appearance, but it is your responsibility to stay in touch with them. If they tell me they can't get a hold of you, I will revoke your bond. Don't pick up any new cases, and that's it. Okay, so I'll have you sign a writ of Victoria. We'll have you get with Ms. Smith for your bond conditions, and then you're free to go. Thank you, Judge. All right. You are Porter Jackson.
Yes, sir.
Mr. Jackson, you're charged with possession of marijuana. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
Yes, Judge. On January 10th, 2025, the officer observed the defendant's vehicle traveling east at the intersection of 2200 block of Spears Road and TC Jester with a defective license plate light. The traffic stop was initiated and the officer made contact with the defendant. The officer observed a strong odor of marijuana emitting from the vehicle and a PC search was conducted. The officer located a green leafy substance believed to be marijuana based on training experience in the driver's side of the vehicle. The weight was approximately 1 ounce.
What was it?
It was on the driver's side.
Mr. Jackson, I'm going to find that there's probable cause to go forward with your case. You run his license. If you don't have a license, you are not allowed to drive. Do you understand, Mr. Jackson? You will be signing an affidavit with me today promising me you're not going to drive. I don't care what's going on in your life. If you want to drive, go get a license, get liability insurance, come back to me, and I'll take this restriction off. But I'm going to tell you now, if I find that you drive, I'm going to sprout horns in the tail. Like, that's how upset I'm going to be. Do you understand? Tell me, did you want to apply for a court-appointed lawyer? Do you mind giving me, please? Yeah. Tell me about yourself. What do you do these days, Mr. Jackson? How old are you?
23.
So what plans for the future do you have? What? Why?
I gotta get a reload. Yeah. That's all. I just gotta get a reload.
You have the ability to make it's just a boatload of money with that license, and I don't understand why you're gonna let it expire. I'm making it a condition that you get a job. You need to get a full-time job. You know that, have you ever explored underwater welding? Have you ever looked into that? How much money do they make? No. How much money do they make? How much is that a year? That's probably like 120, 130 a year. You can make sick money. And come on, man, be better. All right. So do you mind giving me the application? I'm telling you, I'm gonna stay on top of it to make sure that you get that thing back and that you're working, that you're making some good money. Do you understand? All right, come on. Morning, Mr. Pickney. Sir, you're charged with driving on a suspended license. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
Yes, Judge. On January 9th, 2025, the officer observed the defendant's vehicle traveling at the 7600 block of North Wayside Drive with a defective front headlight not illuminated. The traffic stop was initiated and the officer made contact with the defendant, the driver of the vehicle. The defendant provided a Texas driver's license but was unable to provide proof of financial responsibility. The officer found the Texas driver's license to be not eligible with an active SR suspension, and the defendant was the registered owner of the vehicle, and the insurance database showed insurance policy for the vehicle had expired as of March 14th, 2024.
Got it. All right, Mr. Pickney, I'm going to find that there's probable cause to go forward with the case. I'm ordering you not to drive. You will be signing an affidavit with me today promising me you're not going to drive. This is a legal document that you're going to swear to me. If you violate this, I can have a hearing. If you prove it to me that you're driving, I can have a hearing to hold you in contempt and hit you with up to 6 months in jail every single time. Do you understand? So if you drive 5 times, I can have 5 different hearings. Do you understand? Yes or no? Do not drive. If you want to, go get your license, get insurance, come back to me, and I will so happily take this off, but just don't until you do that. It's not hard. You understand? You know, I had someone send me an email not too long ago where they were in an accident and created $50,000 worth of worth of damage to another person, and they didn't know what to do because they ended up just getting sued. Person filed a lawsuit against them, is coming after them. They're, what do I do? What do I do? This is solved by having car insurance. When you're in an accident, that's why we have insurance. So it's not a joke. You look at me like it's, but I'm being serious. I'm trying to help you. Don't, right. Do it the right way. Great things will happen for you. I'm going to give you a lawyer. The lawyer can try to help you out with what you need to do to get your license back. But there's no excuse. If you get into a car, I'm going to lose it. Do you understand? Okay, come on.
Mr. Martin, going to have a special request like this. He was here for the Texans goal. He's from San Diego. Where he picked up the news. He lives in San Diego. He's only here for the games.
So this is, who is this?
Allison Martin.
Mr. Martin.
He's not here, Judge.
Oh.
Gave us like 2 weeks or something.
Okay, I didn't realize.
He called. Oh, yeah. This Ramona, this was like on Wednesday. Ramona came to me, goes, hey, he wanted a short time to be able to get a plane ticket to come here. He was just got up and left.
Okay.
I said, okay. I think we set him for next Friday.
My request is, and I know you want them to be here, would he be able to get on Zoom and get his bond conditions over Zoom, or do you want him to fly here, be present with that?
But is it an assault case? Yeah, no. I mean, at least for one setting, you know?
It's not a domestic violence, it's just a stranger, no criminal history. But if you need him here, Judge, I'll have him come here, no
I
problem.
need him to sign, and I want to, you know, just for one time, and then after that, it's going to be wait. You know? So, and, you know, if you want a week after, I'm okay with that.
Okay.
Give him a little bit more time. But at least for just one setting, we did it in here for the
I
arraignment.
told him that he would probably need to be coming down. Okay, no problem.
Your other guy is who?
David Durant.
Hey, so Mr. Durant, you were charged with unlawful carrying of a weapon. You are facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
Yes, Judge. Okay. On January 11, 2025, the officer was on patrol and observed an odor of marijuana and a male to be smoking in a vehicle nearby at the 8700 block of Lazy Brook Lane. The officer activated emergency lights, positioned himself behind the motor vehicle, and made contact with the defendant. The officer had the defendant step out of the vehicle and advised the defendant that he had been observed smoking marijuana. The defendant stated he was smoking marijuana inside the vehicle because he did not want to smoke inside his friend's home. The officer observed a strong odor of marijuana and conducted a PC search of the vehicle. The officer observed small crumble of green leafy substance known to be marijuana based on training and experience at the bottom of the center console, and 0.37 grams of a small marijuana joint in the ashtray in the cup holder. The officer observed an unholstered black Glock laying in plain view on the backseat floor, and the defendant stated the handgun belonged to him.
Mr. Durant, I'm going to find that there's probable cause to go forward with your case. Do you see if he has a Texas driver license, please?
Don't worry on it.
All right. You're not allowed to drive unless you have a license and liability insurance in your name. Those are conditions of your bond. Do you understand? So those are the only conditions I'm going to put on you. Be careful. Don't do anything stupid. Do not pick up a new case. Otherwise, I'm going to revoke your bond. I'll put you in jail. You understand?
Yes, sir.
You have a lawyer. Listen to him. He'll take care of you. Because you have him, I will waive your appearance. You don't have to waste your time so many courts, but you must stay in contact with him. If he tells me he can't get a hold of you, you pick up a new case, become a danger to my community, I'm going to revoke your bond, put you in jail. So understand? So, all right. So the only thing is just don't get in trouble. Don't drive without a license and insurance. Okay? All right. We will have you just sign the bond conditions, and after that, you'll be free to go. Okay? All right. Thanks.
Thank you, Judge.
Thank you. Manuel Worthy, you were charged with unlawful carrying of a weapon. You were facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge. On January 8th, 2025, the officer responded to a DPS agent who stated he was following the defendant's vehicle and needed assistance on a traffic stop, and the DPS agent was conducting surveillance on an unrelated case. The DPS agent provided a description of the defendant's vehicle, and the officer observed the defendant's vehicle failing to a signal lane change, along with the vehicle's third brake light being out. A traffic stop was conducted, and the officer made contact with the defendant. The officer observed a strong odor of marijuana, and the defendant was asked to step out of the vehicle, and the defendant stated there was nothing illegal inside the vehicle. The officer located a cigar filled with a green leafy substance known to be marijuana based on training experience, with a weight of 0.09 grams or 0.032 ounces. A PC search of the vehicle was conducted, and the officer located a unholstered black handgun inside a backpack in the back seat.
If I may, Your Honor, briefly.
Sure.
Bit unusual. I think the DPS officer, he needs help with the traffic stop. He doesn't state any traffic violations or any reason.
He does, though. Sure he does.
The DPS officer that dispatches says, hey, I'm doing surveillance on this case, on another case. I need help with the traffic stop. He doesn't tell him any traffic violations at all.
And that is true, Your Honor. The officer said he needed assistance, and the officer that was called for assistance is the one who observed the vehicle fail to signal.
So the person that came.
The person that came to respond to the DPS agent calling in assistance.
We just don't know why he needs an assist with the traffic stop at all. He says, hey, come basically.
Because he's doing something else, I'm assuming, right?
Okay.
Isn't that, he's investigating someone else?
Yeah, but I don't understand why he's telling another officer to pull this guy over. He doesn't give him a reason to do so. And we have videos available on this, and I've watched them.
Even so, the officer that pulls him over still sees violations, though, right? If he had not seen violations, I may have an issue.
Right.
But nevertheless, he still sees issues. I mean,
I understand that, Judge. My issue, and this may not be a thing for PC, I've watched the videos. There's no failure to signal a lane change, and you only need 2 brake lights in Texas. I don't know what this third brake light thing is. We can have a suppression hearing later on it. I just want to bring it to the court's attention at the PC determination. And he says, hey, pull this guy.
You're telling me that there's no PC, and one of the issues is because he really does signal a lane change. I'm ready to see it. If you have it, I'm ready to see it. You know, I mean, there's no sense in delaying the inevitable. If there's no probable cause, there's no probable cause. I mean, let's tee it up. I mean, it's only 10 o'clock, right? So,
Here's a moment.
of course,
Yes.
absolutely. But understand, let me finish PC. With everyone, give Alex a moment to also look so he can be prepared. We'll come back, we'll take a look. In the meantime, show me the provision that says you only need 2 red lights as well.
Okay.
Show me the money, and then we'll do it.
Gotcha.
Tell me.
A review of the body cam, we did see the fail to signal. In addition, we did see the high mounted brake light out, which is a third brake light. And under the Texas Code, section 547.3215, the federal vehicle equipment safety standards are adopted, and federal regulation 49 CFR 571.108 requires a high mounted rear brake light. And because that was out, that is
But not all cars have that.
But, well,
So are you telling me now every single car has to have that third mounted brake light?
it requires any multi-purpose passenger vehicle, which in this case it was a sedan. So in this case it is a passenger vehicle. So it has to have, and you can see on the body cam, Your Honor, you can see the high mounted brake light. That's not a cool.
And I would point out, sure, it requires the vehicle.
No. But did you really see that there's no turn signal?
There's no turn signal, and
I would like to see that.
Yeah, we can see that. It's
Can you show him what you saw, please?
yeah, she can pull the video faster than I can.
We have the video already.
Oh, okay. I'm stamped at 0.08. It's you can.
So you're going to see the vehicle come into view at a distance right there, and he comes across 2 lanes without signaling.
Bro, you can come on, Will. You can show the judge that.
Yeah,
you can't.
we can step to the back, and you can see it cut across.
There's no way.
There's no way that's him because
But-
he's already in the furthest right lane by the time that.
No, you
in
can see
2
him.
seconds
You can see
later.
him going across to his right, a lane without any signal, in addition to that brake light as you continue the video.
Would you like to see, Judge?
Sure. Let me see.
You will see your vehicle here.
Which car?
It's may I, Your Honor, go up there and point it out?
The truck.
No, it's the gray sedan. The gray sedan come up.
Oh, it hasn't come up.
You won't see it until after the law enforcement goes over the hill on that.
It looks like he's going pretty fast. Huh? So when you go, I mean, the law is such that you're always supposed to signal, right? And I mean, even if you're going in that turn,
Well,
I mean, were the lights on at that point or no?
yes, the lights were on as soon as he gets up to the back of my client's vehicle before he makes that turn, they just shake lights. And the state is saying that there was an unsignaled lane change required.
How do you know the lights are on?
Pardon?
How do you know?
Because the sound kicks on, you can hear it.
Yeah, and he's correct that after, but before that, there was an unsignaled lane change as.
I was hoping to see an unsignaled lane change before they even pulled him.
There is, Your Honor, it's just.
Show me that.
Yeah, it's a freeway. Well, a freeway, Your Honor.
Show me. I didn't see it.
Yeah, well, if I could, I can point out his vehicle.
Yeah. Show me, because that's what I was looking for and I didn't see it.
Sure. Your Honor, let me step around. So I can-
Go, please. Come on. Don't be shy.
So it's small, it's at a distance, but you'll see the vehicle come into view momentarily. It's right there. That's the defendant's vehicle. That's the defendant's vehicle. Let me go back a little bit.
So wait till it's
Because you can continue, no, and you can continue seeing it.
You're not making, you should be able to like,
I'm sorry, if we're gonna do crosstalk like this, we can just set this for an MAJ hearing where formal motion to suppress and that can be up on the big screen. We can have more structure to an argument and we don't have to have 3 people arguing about it. Here, that's the personal handheld device.
Yes, Judge. And that's the.
I guess you want to set up for a formal probable cause hearing?
You know, he's on an MAJ out of this court. We just have the MAJ. It's a preponderance standard. They can challenge any motion to suppress they want to, or they can urge any motion to suppress they want.
This is for the new case though, right? This is not for the MAJ.
It's for the new case.
It's for the new case.
Yeah, and the UCW.
UCW, yes.
Yeah.
But he's got a pending MAJ in this court for an evading arrest.
Right, but because of this.
Right, so this would have to be proved about that hearing anyway.
Right, but I mean, I'm not going to revoke if there's no PC to go here.
Right, I'm just saying if we're going to be here having 3 attorneys talk about a handheld device on the screen, what can't be seen, we might as well just set it for a whole hearing and then we can put the whole video up on the screen.
I'm down. You want to do it for beginning of next week?
The court suggested that there's gonna be.
I didn't realize it was going to be this
Yeah, I just.
labor intensive, so to speak, you know?
It's turning into like a big argument. If the video is clear enough to determine probable cause, then that's fine. I'm just saying if this is gonna.
I'm having to squint. So that's why. But let's set it for a formal one. Next week, whatever you want. No?
I mean, whatever the court wants.
It doesn't matter to me.
I would like to do it now if we can. It's not willing, but it's, I mean, it's the first, second of it. He said the car is so far away, there's no way. The state's gonna point out a minuscule car to be hundreds of yards away and see what lanes you're in. It's the same. It's just something to follow.
There, and then the officer continues going in that direction. It's the same vehicle.
Is it that one way over there? It's this one, right? It's
The one going right at that time. Because it's going right, then the officer continues in that direction, follow the vehicle.
Can we see it right here? Which one is it?
So it's not right here, it's
How does he even see that?
because as he's coming around the corner, you see it right there, that vehicle right there going right.
Oh, that was cool how you did that.
Yeah, I don't know how I just about it.
That's great. That's it.
So yeah, as
That's
he's coming
it?
around the corner, yeah. So he's coming around And then that vehicle going all the way across with no light and then
Look. No. Come here, Will. Look. He hit something that made it like really big.
You can fix everything. No.
You can see him, he's like, hey, he's like, he's cutting off to try to get out, maybe. You know? Mr. Mercer, do you want to talk about something else?
Yes, sir.
Tell me.
Rehash the previous subject. I was talking to Mr. Martin, the guy who's from San Diego. February 7th, be too late for him to come down here.
It's okay.
Okay, thank you. I appreciate it.
For sure. But, you know, tell him between now and then, he's still not to get, he still has bond conditions that he got from the magistrate. So make sure that he knows that those bond conditions apply, even though he hasn't been here. So, okay. Yeah.
He'll be okay.
I'm okay with that. Yeah, for sure.
Okay, so is that a finding of PC?
Yeah.
Okay, we need to address bond conditions then, back to where we were here in the first.
Come up, Mr. Worthy. Can you see if he has a driver's license, please?
It's Tabloid on it.
Okay. You're not allowed to drive unless you have also car insurance. Do you understand?
So I have liability.
Okay, good. Don't pick up a third case. If you pick up another case, holy moly, I'm just going to lose. Do you understand? Don't. No, you're not supposed to have weapons. No drugs, no alcohol. Did you say there was an odor of marijuana here?
Yes, Judge, a strong odor of marijuana.
Okay. I will test you 45 days from today. If you test positive again for marijuana, I'm going to lock you up. Do you understand? No more smoking weed. So let's set this off 45 to 50 days. His appearance is required. He will get another test on that day. If he's clean, we'll just continue him and then just goes normal. If he's test positive, get ready. You hold the keys. Do you understand?
Sir.
Okay. All right, guys. Thanks. Good morning, Mr. Sarmiento.
Ese es señor Sarmiento.
You
Señor Sarmiento.
were charged with criminal trespass. You are facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney appointed if you cannot afford one.
Yes, Judge.
But it goes slow.
Yes, Judge. On January 5th, 2025, the officer became aware of a stolen vehicle via a flock alert. The flock alert was for a listed stolen blue Hyundai. The officer checked the vehicle's license plate and observed the vehicle stolen as of December 21st, 2024. The officer observed the vehicle turning northbound onto East Tex Freeway, taking the ramp heading north on East Tex Freeway, and ran the license plate, confirming the vehicle to be stolen. A traffic stop was initiated. The officer announced himself as HPD while giving command to turn off the vehicle and place hands out of the vehicle. The defendant, the front passenger, was the last to exit the vehicle, and the officer made contact with the complainant, and the complainant stated he did not know the defendant, did not give the defendant authorization to operate the vehicle.
What?
So they found the stolen vehicle, Your Honor.
How does he know that it was stolen?
And Your Honor, there's no need for him to know this vehicle. There's no requirement he knows, only that he's in the vehicle without permission from the owner. And the owner said he does not have.
How does he even know that the person driving stole the car?
Well, he doesn't know the defendant. He didn't say he know he stole it. He just didn't know he did not give
So
permission.
you're telling me that he's in a car, he doesn't know the driver, and
Right. The complainant just said that in regard, he did not know the defendant, did not give up.
I understand that. I get that, but so he's he's a passenger in a car and they charge him with criminal trespass. And in the DIMS, it says that he doesn't even know the driver. So how would he even know that the car is stolen? How do they know each other? I'm beside myself. I don't. When a criminal trespass requires some kind of like notice that, hey man, you know,
So the trespass was the driver driving into the area and he was this kind of.
he's the passenger, right? I would assume that the driver got charged with UUMV.
Let me see what he got charged with.
If you tell me no, I'm gonna lose it. Really?
Yes, Judge, UMB.
Okay. But the problem is that like, how would he know that the car is stolen? Right? You got to give me something that it's a specific intent crime. You have to, you know, there's got to, in my opinion, you've got to somehow know that the car is stolen. And
Your Honor, first, I guess to get to that, he was in a relationship with the defendant who was in the vehicle, and there were signs of damage to the vehicle that the officer articulated, saying that there was. One moment.
a scratch on the hood.
Signs of theft that would lead a reasonable person to believe the vehicle was stolen, as the steering column was broken in a manner that only a screwdriver could turn the vehicle on, and the screwdriver was tagged into the evidence. So there was damage from a screwdriver in the vehicle indicating that it was stolen, and this defendant was in a relationship with the driver of the vehicle. And then furthermore.
Did you just tell me that they didn't know each other?
No, the complainant does not know the defendant.
Oh, I thought you also said that the driver and.
No, Your Honor, it may just be misunderstanding because of me, but it's the complainant saying he does not know this defendant and did not give permission to the defendant to operate the vehicle.
So there is enough there that a reasonable person would believe
that
he's in a stolen car.
Yes.
So the steering column was
broken, and the officer said that in a manner only a screwdriver could turn the vehicle on.
See, I don't know, because when I was young and dumb and 17, and, my friend had a CJ7, you ever been in those Jeeps that are just jalopy Jeeps, right?
Yes,
they always broke down. They always had a problem. We always, Jimmy rigged it as well,
In this case, Judge, I believe there would be enough for PC because we have a vehicle with evidence of breaking into the vehicle with that damaged steering column.
I've been in vehicles like that before.
And we furthermore have a complainant saying he doesn't know the defendant in the vehicle.
That did no difference to me.
That goes to the element of for the criminal trespass, it goes to with knowledge that it was.
Yeah, no. I'm sorry. I'm going to find no probable cause. Be careful. When you hang with dogs, you get fleas. I don't know what your status is in this world if you're in this country with permission. But if you go to jail and you're not in this country with permission and you spend any kind of 4+ hours in there, immigration will put a detainer on you and you will be stuck like Chuck in there until you get shipped to immigration. So live like a halo, especially if you're not well documented in this country. Go ahead, take a seat for me, sir. You are Mr. Simon Fournier?
Yes. See.
Yes.
You were charged with theft. You were facing up to a year in jail. I'm sorry, up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. If you do not have a lawyer, if you cannot afford one will be appointed to you, sir.
Yes, Judge. On January 11th, 2025, the officer responded to a Walmart in regard to a theft.
The officer made contact with the complainant, and the complainant observed the defendant at a self-checkout with a large amount of groceries. The complainant observed the defendant failed to scan every item in the cart. The defendant was confronted on 2 separate occasions during the checkout process. The defendant was told how to scan items properly, and the defendant failed a 3rd time to scan items properly. The defendant completed the transaction and had unpurchased items past all points of sale, and the total was $184.48.
Sir, I'm going to find that there's enough probable cause to go forward with your case. I'm ordering you now as a condition of your bond not to go to any Walmart. If you violate this condition, I'm going to put you in jail. I don't know what your immigration status in this country is, but if you're not in this country with permission and you go to jail and immigration finds you, they will put a detainer on you and you'll be stuck in there until this case is over with and then shipped off to immigration. Behave yourself, otherwise I'm going to lock you up. Do you understand?
Yes.
Yes.
You have the ability to hire a lawyer.
Sí, me lo pondría.
Yes, can you give
Do
me
you want
one?
to apply for a lawyer?
¿Quieres aplicar por un abogado de oficio?
¿Yo puedo hablar?
Can I speak?
No.
No.
But you can have a lawyer if you want one.
Puede tener un abogado si desea.
Sí.
Yes.
You need a lawyer.
Necesita un abogado.
Sí.
Yes.
Okay. I need you to fill out an application for me. I'll have you sign a wreath of Victoria. Wait. We're not done. Do not leave until you sign our bond conditions prohibiting you from going to any Walmart. Do you understand?
¿Usted lo entiende?
Now you're done. Good morning.
Good morning.
How's jail?
It sucks.
Great. It's supposed to. Not supposed to be fun.
Yeah.
Problem is every time we give you a bond, you have like little wings. You take flight.
I don't take flight. It's just, okay, so.
Okay, you don't show up.
To be real with you, my transmission on my car literally did break down last time. And this time I made sure everything.
Take a bus. Phone a friend.
Well, where I live, it didn't have a bus route. But I do have Uber already ready, already scheduled. So there's no chance that I'm missing bond. Like, there's no reason why I would even miss anything.
Shame on, fool me once, shame on you. Fool me twice, shame on me. Fool me thrice, what is it? You've taken off on me 3 different times and you want me to give you a 4th bond? Really?
I want to prove myself too.
Mm-hmm.
Literally. Like, I have what it takes.
And Judge, I'll say, I have her information. I have information of her boyfriend and some other people. And my office will hound her, will call her and make sure that she's
I'm
there.
all about giving people multiple chances, but I've already given you 3. At some point, I have to say when, because if I don't, then I've done it 3 times. You and I have had this conversation before. The last time I let you out, we had the same conversation we're having now.
Yeah, I know. But literally, I'm done. Like, this is it. Like, I don't want to see myself back here, Judge. Like, I don't want to do this anymore. I don't. Like, I want to prove to you. I want to prove to my family and myself. This is it. Like, I don't want to do this anymore. I have a kid. I have a job. I'm fully time employed. Like, I don't want to do this anymore. Like, this is it. This is it for myself. I'm speaking 100% just you and me.
I don't believe you've sold me this. You've sold me the snake oil before,
I've never actually got.
Sean, what I would like to do, and I agree with you that you can't keep doing what you're doing, especially if you have kids, because, if you're a mother,
I am. I just want to come home.
that child needs you.
I know.
Hey, where's mom? She's in jail.
I don't want that to respond.
So what I would like to do, because this case has been open for a long time, perhaps do a TRAS. Let's see what they say, and we'll go from there. But so I have clinicians on staff. They can tell me exactly how we need to head. They will interview you, see what's going on in your life, to find which fork in the road to take, how to take it. They may say, okay, let's get her to do outpatient treatment. They may say, let's get her to do inpatient treatment. They may say she needs no treatment.
I don't want to do that. Can I take the conviction? And I know what I'm looking at. I understand what I'm looking at.
I don't want to say that.
What I'm looking at.
You need to talk with Sean about that,
So,
right?
I have.
Your Honor, just my concern. Look, I don't want to render an involuntary plea or anything like that as a result of her wanting to get out. our conversation back there was for a decent amount of time, and I have no problem, like I said, absolutely hounding her to make sure it happens so that she can be here. And if she's not, that can be on me.
Sean, that's the fourth time. I'm not going to do it.
So
I've
if it's,
done it. We had the same conversation the last time we were here.
So if it's not in the arena of PR bond or anything like that, can there be a number assigned, a set and fail amount that she want to make? If, in the event that she can.
I will give you a bail reduction, of course. I will do something reasonable just hold on.
Okay, but I can't make bond. I know for sure I cannot make bond right now. I know if I do the conviction, I know what I'm looking at next time, and it's a state jail felony, and I'm willing to take that. I'm willing to take all of that. I need to get home to my kid. Please, Judge. Please. I know what I'm looking at.
I would think.
I'm comfortable with it. I'm comfortable with that theft charge on there. I know what it looks bad. I do. But I'm willing to take that right now to get home to my family.
Whatever you guys want.
Okay.
So if you think this was tough, wait till you get upstairs in felony court. It gets so much worse.
No, there's not gonna be another.
If I had one strand of hair every time someone told me that,
I get that.
I would look like Alex.
He has hair.
That's my point. Every time someone told me that excuse, if I had one strand of hair, I would look like Michael. Well, not like you. Whatever you guys want to do, you know me. Look, hey, I can't keep doing it. I have to show you that we mean business.
And I know I do. But let me show you that I mean business as well.
Okay, so let's do this. Let's do a deferred where it stays off your record.
I want it on my record though. I want that on my record, and I want to take that on. I do. I really do. No, I do.
So how about this, Judge? Me and her will talk.
But just hear me out. Look, I don't want to keep you on paper forever. But if we were to do the TRAS and you do treatment, as soon as you're done with the treatment, we'll successfully terminate.
I'd rather take the sex conviction, in all honesty. I'm comfortable with that. I know what I'm looking at.
Don't want to clean up?
I want the sex conviction. I do. I want to take that.
Guys talking, let me know what you want to do, Sean.
So just for the record, so at this time, personal bond or reinstatement is off the table. And then if a bond amount is set, what would
The bond's set at 7503. So if you want something different, I'm happy to give it to you.
Okay.
Whatever, something reasonable, whatever it may be,
Okay.
You have the conversation. If you want to, you just got the appointment today, right?
Yes.
If you want to roll it to Monday for you to do your diligence, that's also a possibility. So whatever you guys want to do, you let me know.
Get it worked out.
Okay, thanks, Sean. Okay. You got to know, your record stands out for itself.
Yes.
No matter what your circumstance is, criminality is still criminality. Whatever you're doing, if you need anything, we can help you here. If you want it, we can give you whatever you need. If you want treatment, if you want a cell phone, if you want a tablet, if you want a place to sleep, if you want to eat, we have resources here that we can help you with. And for as long as I'm here, because who knows how long I'm going to be here, if you ever come back and if you ever want anything, I'll give it to you.
Yes, sir.
All you have to do is ask. And I know that the thing is that, I get that you want to party, right? And
Not really. I just want to.
just listen, I get it. That lifestyle is going to catch up with you
Yeah.
because, life does not get easier the older you get. It gets difficult. You get bigger, you get fatter, you get uglier, you lose hair. Life doesn't get easier.
I'm fine.
I want you to listen because you're thinking about what to say. You're not listening and internalizing what I'm trying to tell you, that it doesn't get easier. And I know that you want to get out there. You're ready to get out there, go party and just where. If you don't have something, if you don't set yourself up with something, with a skill or some kind of trade or some kind of job or knowledge, you're going to end up lickety split at 50, at 60, destitute, alone, toothless, with no money on the street. Life doesn't get easier. And what you're doing now is you're only hosing yourself worse and worse. It's like we are watching you crumble. And I want to help you, but you just don't want it. And that's okay because you can lead a horse to water, but you can't force him to drink. But it's going to catch up with you.
Yeah.
Don't let it. I'm telling you, in a moment's notice, 10 years is going to pass. And if you keep there,
Yeah. Yes,
you're
sir.
charged with theft. You're facing up to 6 months in jail and or a $2,000 fine. The agreement that you've worked is 9 days in jail, credit for the 7 days that you've done. You have to understand this now makes 2. On the third, you're looking at a state jail felony, minimum of 6 months in jail.
Yes, sir. This is it, though. I think this is the last time we see each other, for sure.
Well, it is because
Oh, I know,
from
though.
now on, another case, you're going
Yeah.
upstairs to felony court. I'm not going to see you.
Yeah, gotcha.
But this is going to trail you for the rest of your life. Once you plead guilty, you can never take it off. You can never say, you know what? I should have done something else. That's so stupid. Are you sure you want to do this?
Sure.
You don't want a short deferred where we can make minimal conditions. It won't go on your record.
I'm positive I want to do
You are giving up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. Once you plead guilty, there's no changing this. If you ever want something, come back. I will help you as much as I can while I'm here. All you got to do is come back and ask for whatever it is. It is so much that if you want to change this, I have jurisdiction up to 30 days. If you come back, you know, whatever you need.
I'll really put the into it for
How do you plead to the offense? Guilty or not guilty?
guilty.
I'm going to find you guilty. I will follow the agreement. Good luck. Good morning, Mr. Esquivel. Sir, you're wanted for out of the state of Washington. You're wanted out of the state of Washington for murder, attempted murder in the first degree, 3 counts, drive-by shooting, and conspiracy to commit first-degree murder. Are you waiving formal extradition, sir?
Yes.
All right, sir. Thanks.
Thanks, Judge.
Thank you. Are you Frank Hunter? Good morning, Mr. Hunter.
Good morning.
Sir, you are wanted out of the state of Maryland for first-degree felony assault. Are you waiving formal extradition, sir? Are you waiving formal extradition?
Yes.
Okay. All right, sir. Thank you so much. Good luck. All right. Good morning, Mr. Cortez. Mr. Cortez, you are wanted out of
Calcasieu Parish, Judge, Louisiana.
residential contract fraud, $5,000 or more, but less than $25,000. Theft from $1,000, but less than $5,000. And thirdly, failing to possess the required license for home improvement. Your lawyer is asking for me to set you a bond. I don't know. I don't know anything about you. I know that you're going to tell me that everything is little sunshine and rainbows and gumdrops, but I have to know everything about you, and so I have Mr. Kim here to help me with that. Please.
Your Honor, Louisiana is requesting that there be no bond until he's returned. However, they have informed me that this warrant, while issued out in 2022, is a 2B warrant and it's not a failure to appear. The remainder of his history is in Harris County, the failure to ID and the assault family member. State just asked that reasonable bail be set at $7,500.
Judge, I would ask that you be allowed to go turn himself in or to put your bond out there just for 2 days. So you don't have to wait here.
I'm okay with giving the bond.
Okay.
How is the amount? Because
I would ask for $2,000, Judge.
I think that that's just probably a little bit too low.
Okay.
I have to set your bond sufficiently high so that I know you're going to go back to Calcasieu Parish, Louisiana. You have to understand that we don't play games here.
I know.
We give you one chance and one chance only. If I set you a bond and you fail to go back, you need to understand that there are very grave consequences. The consequence is that I'm going to revoke this bond. You will lose all that money and I'm going to set it at 0 and I'm not going to play this game with you again. You will wait until Louisiana comes and gets you. Do you understand? So once again, let's split the puppy, right? You're asking for 7,500. You're asking for 2. Let's split. So, huh?
Is that 4,000?
I was gonna say 3,500 because I'm not good at math,
I'm
but
not good at math either.
no.
That's, I don't.
So I will set your bond at $3,500. But the only other thing I'm going to counsel you is, Mr. Cortez, don't wait until the day before to go back, because as Murphy's Law dictates, what can happen will. And I don't care if you break down, if you're a death, I don't care. You understand?
Yes, sir.
Okay. That's him?
Yes, sir. Let me see if I can get this right. Adrian Johnson was supposed to. Adrian Johnson was supposed to have had a court date here on 12/12/23.
23.
23. However, Adrian Johnson during that period of time had gone to Atlanta, Georgia. While he was in Atlanta, Georgia, he picked up a possession of marijuana case where he spent 1 day in the jail and he got out. He didn't get out. Instead of getting out, they transported him to Appleton, Georgia, where he picked up a theft case, and he stayed there 13 months. Therefore, his reason for not being here on time was because he had went to Atlanta, Georgia, picked up a possession of marijuana case. Then when he got out, they didn't let him out. He had already had another warrant on him for a theft case up in Appleton, Georgia.
Do you have a cause number by chance?
Yes, sir. We have.
No. For our case here.
Yes, sir. 247-6875. So I'm respectfully requesting to reinstate his bond or give him another PR bond, Judge.
Mr. Johnson, you were charged with burglary of a motor vehicle. You were facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
Yes, Judge. On September 22nd, 2023, officers were dispatched to a lawn management company at 630 Rankin Circle for a burglary in progress. The defendant and a co-defendant had cut through the fence surrounding the property and were searching through vehicles at the location. There were surveillance videos of the defendant and co-defendant inside a van on the property.
Can you run an NCIC on him? I'd like to know what, if anything, has happened from the time that he picked this case up to the time he's now back in front of us.
Yes, Judge.
I don't know, Mr. D. Guys, he has a warrant for now, and I don't know if I'm going to give him a PR bond. I want to see how he's been since September 23. If you've been on picking up cases like it's just left and right, then I don't know, man. But
Yes, sir, Your Honor.
my only concern is my community. That's all I care about, and I'm going to do everything in my power to protect my community. If you've just become a danger where you're hopscotching states and you're playing hopscotch and you're picking up cases while you're hopscotching, no. The revolving door closes.
So I do see on December 7th, 2023, the Georgia case, theft by taking, but that's the only other case.
Is that a felony or was that a misdemeanor?
It's felony, Your Honor.
What was it? Do you have a disposition?
No, there's no disposition listed.
13 months per him, Judge.
Anything else he's picked up?
No, Your Honor.
I have the, oh man, swoop. All right.
I'm going to reinstate your bond now, but I'm not going to do it again. If you take flight on me again, I'm telling you, I'm going to make it high. No more PR bonds for you. You got a little kid in your charge, man. Be the good father that you should be. Teach them right, because they look on you for support and for them to do the right way. They see this. We don't need more. Know what I mean? Come on, man. Be better. I'm placing bond conditions on you now that you're not to go back to this location where this occurred and you're not to be in possession of weapons. Don't pick up any new cases. You've got a great lawyer here. Just listen to him. He'll take care of you. If I find that you're becoming a danger, you know what's going to happen. I don't have any tolerance. We have nothing but death and destruction on the news. I don't want any more. Do you understand? So, all right, man. Good luck. Don't leave until you sign the bond conditions. Okay.
Thank you.
That states bond conditions?
Yeah.
You said bond reinstated?
Yeah.
Your Honor, can you hear me, sir?
I can hear you. And let me tell you now that I really haven't seen a lawyer go above and beyond the call of duty as Bayoji has done in this case. Everything and every time you have been back here is because of something that has happened, something that has failed to happen. The last time here, all you had to do was provide documentation that you could not afford whatever it was. You have failed to provide that documentation. As a result, they've now kicked you out of the program. I know that Bayoji is going to give it one last shot as to whether he's able to either get the case dismissed, get you back in. I don't know. But I am now putting this baby to bed. So I will give you a week. Is that okay?
Yes, Your Honor. That should be enough time.
I am not waiving your appearance anymore. And in the next week, if he is unable to get you back into the program, if he is unable to get the case dismissed, you must either accept the plea bargain agreement from the state, or I will immediately set your case for trial, and it's going to be a very short trial setting. Do you understand?
I understand, sir.
It's unacceptable that we are now at 800 days, and they have literally over and over and over bent over backwards to help you. And if I were you, I would probably just, I can tell you now that Bayoji's not very happy with you as well.
I'm not happy with myself too. And
So-
I don't have power over the old situation.
I don't want you to say anything. Don't say anything. There's nothing you need to say. The only thing that matters are actions. You telling us something it goes in one ear, it goes out the other ear. Because when you get out there, we still have issues. So I don't care. I'm giving Bayoji a week to do what he can do. If it doesn't work out and it doesn't end up getting dismissed, you must be here in court. If you fail to appear, I'm going to revoke your bond. Do you understand?
I understand, sir.
Thank you, Your Honor.
Hold on.
Thank you, Your Honor.
I want to give him the date.
Oh, yep, you did.
So don't go, because I want to give you the date so I can mark everything down so that you knew exactly what day and what time you had to be here.
Okay, sir. I'll be there.
You must be here January 30th. If the case is still active and it doesn't get dismissed, you must be here in person on that day and either accept a plea bargain from the state or we will immediately set it for trial. Do you understand?
Yes, sir. Thank you.
All right.
Thank you, Your Honor.
Good luck.